Good morning, everyone. It is November 19th. This is a regular meeting of the Board of County Commissioners. Normally, public comment is first unless we have administrative approval of marijuana licenses. So we'll do that first. Nanette.
Be quick. Good morning. Thank you. We just have renewal applications submitted by XLNY and TKN Industries LLC, both for the retail marijuana products manufacturing and medical marijuana products manufacturing licenses. All the departments have reviewed the applications and approved recommended renewal. Sorry.
Okay.
So I think we're good.
Based on the staff recommendation, consider them approved.
All right. Thank you.
Thank you. Now it is public comment.
I don't know if the person.
So if you are on Zoom and you would like to make a public comment, please raise your hand. I don't believe there's anyone in the room for public comment. Although it's always an option.
Yeah. Most people online are staff and nobody's raising their hand. So.
Thank you so much. You feel it.
I was just hearing about a commissioner
Oh,
that
yeah, fine. Yeah.
would go and make public comment to their board. Okay, I'm gonna close public comment. Next on the agenda is county commissioner updates.
I hadn't thought about that.
Oh, thanks.
Randy, you want to kick it off?
Sure. There are several things going on, but really, I think the only thing that's on my mind this morning is I attended a memorial service this weekend for Greg Markle, our longtime county surveyor who's left recently. And as we know, he was a picture in the community, having founded K-Goat Radio and made several movies, some of them for fun and some of them for public service for different organizations here. And I had intended that we would have a resolution of appreciation for Greg Markle, and I know I promised to do that, and I just realized that I have not done yet. So we will have a resolution for Greg Markle before December, but in honor of Greg Markle, I would like to play a piece of music for him, if you don't mind. Thank you.
Thank you for remembering that, Randy. It was a great service. I was left pretty inspired. Our community has done some really cool and hard stuff, and we still can.
Nothing for me.
Okay, a couple of things from me. The first is you all might have received an email from CTSI, County Technical Services. I assume the I is incorporated, regarding the use of expired Narcan, advising against the use of expired Narcan. I responded to the email sort of asking for feedback from staff at GROC and our EMS director and others. What I learned was what I thought I knew, which is that the use of expired Narcan is completely safe. And the only possible impact is that it's slightly less effective. And so I have asked CTSI if they would give me a sense for what can be done to change their risk calculation. If there's any rulemaking or legislative venue that can change here. What I know is our EMS director reached out to his medical advisor. His medical advisor, I can't remember the name of the doctor, responded saying, yes, please. If your choice is to use expired Narcan or watch a person die of an overdose, please use the expired Narcan. I've asked that message to be spread amongst our staff that carries and uses Narcan. And I'm kind of alarmed by the chilling effect that this will have, because CTSI serves almost every county in the state of Colorado. And they all just received this, I think, pretty harmful advisory. So I reached out to the Attorney General, asked them, I've got a conversation with the Attorney General to ask them if they have anything that they may be able to do. I am talking to legislators and basically anybody who will listen about this. So I want you guys to know that if you hear I'm out there causing trouble, it's true. Second, on the GROC, the Gateway to the Rockies Opioid Council, in my last update, I told you that we have a municipal representative that's willing, that I think is very qualified. Her name is Janine Mariani. What I forgot was two things. First, that we need to appoint an alternate. I have not identified an alternate. And so I've asked the mayors to identify an alternate. And we didn't have a conversation about what we want to interview Janine Mariani or the law enforcement rep, which needs to be reappointed, is the district attorney, Heidi McCollum. So do we want to interview Heidi? Do we want to interview Janine? That is my question to you.
What would cause you not to follow what appears to be a traditional process?
I can't come up with it.
I'm fine with the interviews.
Okay.
So
Then can we ask staff to set up interviews? I can provide contact info with Janine. I presume you have it with,
those happen in the,
Janine
Assume we-
and Heidi.
happen.
they would need to have, we need to make those appointments this year so that those people can be seated in January.
So Janine
Okay.
and Heidi.
Janine and Heidi.
Okay.
I don't think that it makes a lot of sense to interview an alternate, but that's not a firm. Any firm opinions on that?
No.
Okay. That is the balance of my update. Thank you all.
So interviews would be possibly December 10th so that the resolution could be brought on the 17th. That work?
Yes.
So, and hopefully we'll have the alternate names to include in the resolution by the 17th.
Yes.
Thank you.
Okay. Anything else? No. County manager update.
Good morning. Beth, put the equipment list in front of you. Just kind of friendly reminder that we need to get that adopted probably second meeting in January, I would assume, with the new board. But you got several names on there that need to be modified, a couple of assignments from the. Just, kind of a friendly reminder for you guys. That's an action that's coming January. Friendly reminder, we canceled first meeting, or we moved our first meeting in January, or in December. Due to the CCI conference to December 10th. Randy, do we need to discuss a JCMH appointment for Chad's position, the joint position with Gilpin,
Not for Chad. Well,
to replace him, right?
yeah, but we don't. I'm trying to remember the protocol for that. We don't, it's not our, I don't believe it's our appointment for Chad.
Is it a joint between us and Gilpin?
Yes. And so, and there was we made an error, actually, well, it was an unnecessary interview we did of Chad recently because he was not being reappointed at the time. But that's water under the bridge now. But so we need a process to do that with Gilpin, I believe, together.
Okay.
And I believe he's term limited and going out now. So
You want us to reach out to Gilpin?
I think so.
Okay.
Right.
We can do that.
It would also be awesome if we could think about a Clear County resident or staff person that might be a good fit. Of
Remember, it's a joint appointment between us and Gilpin, right? So we got to agree on the appointment.
course, yeah. And so, they might want to know if we have any, we might be as interested in ourselves as we are in them is all.
Sure.
And I think I believe there's term limits on that. So Chad's doing a great job. If he can be reappointed, it would be great. I mean, we're not losing anything with Chad there. That's my personal opinion.
Sure.
But I believe he's term limited and has to go now. So, but if we can just confirm that, in case my memory's faulty this morning.
Saw Commissioner Hollingsworth asked if they would change their bylaws to let him stay on longer, but I didn't see a response from.
I was at the JCMH meeting and I don't think that's a thing.
Okay,
We had a retreat this last week, so
Okay.
there's some more commissioner update there.
all right.
Heads up, we're scheduling an employee holiday party for I keep saying January, December 19th, Thursday. Kind of the typical party we've done in the past. But just a heads up there, that's the date for that. We have not put that out, so if that's isn't gonna work for you, let me know that, but your consent agenda includes a professional services agreement with Axiom for IT services for the county. I did make a decision to waive the purchasing policy in order to bring them under contract. So that contract right now is on consent. As you recall, we no longer have an IT director. We made the decision to work with Axiom as opposed to recruiting for the position. They were already doing work for our sheriff's office. We've now, the agreement that's on consent does include work for the entire county. So it's the work that's happening already in the sheriff's office in addition to what we need for the county. Our intention is to reassess that agreement probably 3 months in, maybe somewhere in the first quarter of 25 to assess whether we're going to go out. To make the decision whether we are going to go back out and actually follow that purchasing policy and go back out with an RP and or look at the hiring the position that we have on the books right now. So that's just a heads up there, what's on your consent agenda and the fact that I needed to alert you to the fact that I did waive the purchasing policy to bring them on board.
Do we want to have a work session on that? On the future of IT?
On the future of IT?
Yeah.
Yeah, I think we need one.
For the end of the year. I'd like to see the ability to work with Axiom for a bit before we have that work session. I mean, that'd be helpful for us to be able to re-engage with Axiom before we bring that work session to you. I mean, if we'd have more intel on our side.
Well, I
in order
mean,
to have that.
I mean, my intent is just to ask for an RFI before we think we have enough information to make a decision about RFP or hiring internally. Maybe we don't need it if.
Yeah, I think you guys are saying the same thing.
No, that's
it's
not
just-
quite the same thing.
You're suggesting having a conversation of some sort in 2 to 3 months.
Yes,
And I think that's what I heard George say just now.
except he also indicated we need to do an RFI before I do an RFP, and that's an extra step that I'm
Okay.
not contemplating right now. So
The RFI is the extra step. You're not
Correct.
contemplating.
to me, we're getting what we need from a contractor versus having our own staff member in place. I suspect that the cost is only gonna go up when we go out and do the RFP. So those are part of my concerns, so.
Okay.
Yeah. And then I apologize, I failed to program in a break onto your agenda, so whenever the chair and the rest of you think it's appropriate to.
Whenever I can be released to go get my phone that I left at home would be fine. Then I can see how my life is progressing.
And that's it.
Okay, let's see how much we can push through. Randy, let's try to get you
Yeah, I'm good.
by 10 or so.
Let's just do the meeting.
Communications update, Megan.
All right, just one quick thing. Chat and the sheriff's office are doing a community partnership meeting that's taking place on Wednesday, December 4th from 6 to 7:30 at the rec center. Basically, if you're interested, you can come learn about how to support people in crisis. You can learn about resources and things like that. If you can't make it in person, a Zoom link is also available. So that's going to get pushed out there and you guys can see that and encourage anybody who wants to come to come. That's all I got.
What's the date again?
Oh, I'm sorry, December 4th.
December 4th.
That's on a Wednesday and it's 6 to 7:30.
Thank you.
Mhm.
Next thing on the agenda, we're now sitting as the local liquor licensing authority. This is I'm gonna call it a quasi hearing. You need to consider approval of optional premises liquor license for Clear Creek County Skiing Corporation, doing business as Loveland Ski Areas. I believe that I can ask for public comment, and if there can be approved administratively. I'm going to ask for public comment. Is there any public comment on that application?
50 a.m.
No one online.
Okay. A note from the packet that staff recommends approval of that, and that we did receive all of our referral responses.
Everything was correct and in order.
Okay, consider it approved.
Great, thank you.
Back to sitting as the Board of County Commissioners consent agenda. Anything that we want to pull for discussion?
I don't want to pull anything, but I have comments when we get there.
Okay. I'll go ahead and read it. Item A, consideration of approval of the warrant register. Item B, consideration of approval of 2021 Board of County Commissioners meeting minutes from July 20th, 27th, August 3rd, 10th, 12th, 24th. Consideration of approval of 2024 Board of County Commissioners meeting minutes, November 5th, 13th, and October 30th. Item D, consideration of approval of resolution 24-74, a resolution ratifying the rescission of the Clear Creek County Fire Ban declared on September 3rd, 2024. Item E, consideration of approval of resolution 24-75, a resolution designating David Danielson as the zoning official for Clear Creek County. Item F, consideration of approval of a contract to buy and sell real estate land. Item G, consideration of approval of resolution number 24-80, resolution granting signature authority to execute real estate documents for the purchase of real property. Item H, consideration of approval of resolution 24-81, a resolution to amend the 2024 original appropriation for Clear Creek County funds / Floyd Hill parking lot budget project revision. Item I, consideration of approval of professional services contract with Axiom Group LLC. Item J, consideration of approval of change order number 7, number 8, number 9, and number 10, and third amendment to Clear Creek County Sports Shooting Complex Unified Form Construction Contract with Henry Construction Incorporated. And item K, consideration of approval of resolution number 24-72, a resolution to appoint members to the Clear Creek County Tourism Bureau Board of Directors. I'd welcome a motion to approve the consent agenda.
So moved.
I'll second that.
Okay, any discussion?
I got a couple items. Took me a second to find them. I appreciate that the fire ban there currently isn't one. Who's responsible for picking up all the signs?
I'd be sheriff's office.
They're still in my neighborhood. There's still one on Highway 40 as you go westbound from County Road 65. I'm guessing they're probably everywhere still.
I thought Road and Bridge played a role in that also.
Well, whomever it is, we'll figure it out.
Okay, the sandwich boards are, getting plowed into place right now.
Mhm.
So my next comments about the Axiom Group contract. Some industries evolve more slowly than others. And technology companies typically use terms like whitelist and blacklist and master and slave when they're referring to pieces of equipment. And I just ask that in the future, we could try to avoid terms like that in contracts. It is, in fact, in the scope of work for Axiom. So maybe in the future, we could avoid those terms.
Thank you for that.
Yep.
Also want to share with everybody that the next Henderson CPP, it's roughly 3 months from now, the focus is water. And since water showed up in the consent agenda, we might want to make sure staff is aware of that. That does it. Thanks for your time.
Okay. I just want to note we are appointing two members to the Clear Creek County Tourism Bureau Board of Directors. Want to express some gratitude to Amy Van Windenkamp and Joshua Walker for their volunteerism and service to the people of Clear Creek. That's all from me. We have a motion and a second. All in favor?
Aye.
Aye.
Motion passes. Next on the agenda. We are now sitting as the Board of Equalization to consider the Board of Equalization consent agenda. Does anybody want to remove any items from the Board of Equalization consent agenda?
No.
Okay, I will read it. Item A, consideration of approval of August 4th and September 29th, 2020, and July 20th, 27th, and August 3rd, 2021, and July 31st and August 5th, 2024, Board of Equalization meeting minutes.
I move we approve the consent agenda.
Second.
Motion and a second, all in favor?
Aye.
Aye.
Aye. Motion passes. Okay, time to get to work. We've got Board of County Commissioners action sessions. Item 1 is consideration of approval of resolution number 24-78, a resolution revising the Clear Creek County Water Bank rate schedule with Lisa Lieben.
Good morning, Commissioners. Thank you for passing the change orders on the shooting range. As the agenda stated, this item is consideration of a new resolution. I will not, in the consideration of time and a very packed agenda, I won't read the memo or outline a lot of details. Hopefully the packet answered questions and addressed the issues. We have not raised rates since 2017. So when we initiated the program, we thought we would actually do it every 5 years. But that's pretty quick. And we realized, though, we are not keeping a market. You may recall the work session we had where we presented the Di Natale rate study. We've been working with our water engineers and water attorneys to develop the new structure, to looking at what the market rate is, and based on the study of the other augmentation plants in Colorado and their rates, and putting all that together and looking at the CPI increases in many of our contracts, which was a good thing because it kept up the rates up. And so some of our customers will actually see a decline in their price per acre foot because it exceeded that what we are establishing. And most of the contracts, every contract is unique, so I can't generalize. Most of the contracts do say once we set a new rate, their rate then the new rate is applicable to their contract rate. So we did look at all 21 customers that we have. The new rates we believe are in line. So I will open it for questions.
I have one. I don't, maybe this might be a Peter question. We have very few tools when it comes to incentivizing economic development. This is one of them. This is definitely the best one that we have. And what I don't see in this, and I don't mean this is a critique, this is a conversation that would need to come from the board, is any differentiation among water uses that, those that we prefer, those that we think are good for our economy. I'll give you an example. Would we want to offer a lower rate if we had someone trying to build housing with a price commitment on it? Or if we had someone trying to start a business that had good paying primary jobs? Does this contract, does this resolution allow anywhere in the organization, whether it's the board or anybody else, to make those kinds of determinations, or would we need the board to be proactive and have a work session and then amend this resolution in the future to be able to do that?
It would be the latter.
Okay.
Do you agree?
Resolution policy.
The resolution adopts the policy, so we would have to bring back a new resolution with the amended policy. And I do think that's something that can be done.
Board, I don't know how you feel about this conversation. I would love for us to build some policy around how we might use this water bank as a proactive economic development tool. One of the things I hear from our economic development director all the time is whenever I'm talking to trying to recruit a business, they ask me what kind of incentive policies are out there, and my answer is I'm not aware of a single one by any jurisdiction in Clear Creek County. And I don't think that that is what we want our economic development director to have to say. So are you interested in directing staff to bring either this board or another board a work session to consider this policy?
I would say wouldn't be in context of just considering this policy in a vacuum, in a silo. Be have a I would recommend, because it's not going to happen on my watch, but I would recommend a work session to discuss incentives in general and what incentives there may be out there, rather than just take one policy and think about whether you want to do it with that policy and another with that. Because the economic sustainability of our systems, including our viability for water, there are a lot of pieces that feed into that. And I think you need to think about all those and make sure that they're sustainable. You have sustainable policies that are sustainable for operating, for executing our resources and disposition of them.
I like the idea of broadening it, and I'll go as far as suggesting it might fit underneath the regional resilience team's work.
And it should land it should land in front of the commissioners at some point, obviously. That has to be part of what the commissioners do too,
Sure.
I think.
Staff, what do we think is a reasonable expectation for when such a work session could be brought to a board?
Well, I think there might be some value here, and you're gonna have 2 new commissioners coming online. We're gonna have to educate them also about the water bank itself and how it can be used. And I think that might be the opportunity to hold a work session to both help them understand what the water bank's purpose is, and then have a conversation about your thoughts on how we might be able to use it as a better ED tool moving forward.
I kind of like Randy's idea of asking for a work session on sort of the broader topic of incentives and what else might be out there.
Understand it's a short list.
Yeah, I'm aware that might help motivate this conversation because it might be the only thing on the list we can afford. So
It'll be on the tickler. But we'll get it
okay,
coming back for sure.
3 months.
Oh, yeah.
So maybe we can count on seeing that in the first quarter of next year. Okay. Finally, that's my only comment. Otherwise, appreciate the study, appreciate the work, support the policy. Other thoughts?
I support the policy. I think it's good work. Thank you.
Then I'd like to move that we approve resolution 24-78, revising the Clear Creek County Water Bank rate schedule.
Second.
We have a motion and a second. Any comment?
Thank you.
Thank you.
All in favor?
Aye.
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 Passes. Next on the agenda is consideration of resolution number 24-73, a resolution repealing resolution number 121 and adopting a new licensing program and fee structure concerning the use of county real property by river outfitters with Amy Saxton. Where's yours?
Thank you. Commissioners, I'm sorry, I have to log back into my computer one moment here. We are here today to discuss an update to the Commercial River Outfitters rafting program. We presented a work session to you earlier this fall to present the proposal, which consisted of simply a increase in the fees, which staff proposed an increase in fees, bringing it from 50 cents a person to $1 a person. You offered some feedback to us on that, which is represented in this proposal. Which asked us to not only increase the fees from $1 per person, but add a change in the way we approach those fees to make sure we are charging for the use of each access point, which we have done and is currently reflected in the document. That is those are the primary changes reflected in this document.
Okay, questions?
No.
I don't have any questions either. I have a comment. We did receive an email from the, what do they call themselves? Rafting Outfitters on Clear Creek. Organization representing the rafting outfitters.
Yes.
They suggested that these fees may be prohibitive. It's my understanding that the fee is relative to what they're charging on the Arkansas, for example, which is the most drafted river in the state, are higher than this.
It is. That is our understanding, that the fees are higher. And the way this looks to me, to staff, is that currently with our fees at 50 cents a head, that means that a trip could cost anywhere, for a permitted trip could cost anywhere from 50 cents to $1.50. If a trip only uses a Clear Creek County permitted access point and no other access points, that trip might cost 50 cents. If a trip only used an Idaho Springs access point, that trip might cost $1. If a trip uses a Clear Creek County access point at the current rate of 50 cents and an Idaho Springs access point at the rate of $1, that trip could cost $1.50. So in this scenario, a trip would basically always cost $2 and no more. If they used Clear Creek County access to embark and disembark, that's $2. If they use Idaho Springs to embark and disembark, well, they couldn't do that. If it could cost $1.
Short trips.
It could cost $1 if they disembarked at a non-Clear Creek County place but embarked in Idaho Springs, that would cost $1. But it would never cost more than $2 is the upshot. So that's still a reasonable per person rate.
What about access points in the unincorporated county that are not owned by the county?
We are making good progress on the biggest one is the area around Two Bears. And we are working on a lease agreement with CDOT to allow us to use that access point.
To charge the fee at that?
To charge a fee at that access point. Right now, that is not included in our permit program.
Okay. And there are no other cases like that in the county, is that correct?
Not that have a significant amount of use. There is one that is a little bit that's near that 6 and 40 intersection. There's a parking area there that rafters sometimes use to take out. But it's not very common, but that would not likely to be included in the permit program.
DLD?
No, it's further east.
But I'm saying in addition to that, there's
Oh.
nothing up by DLD either.
Well, we have Upper Dumont, and that we obtained rights to use when we improved the parking lot there. And then there's Lower Dumont. We do have rights to use.
Mhm. Okay.
And we have Lawson.
Okay, thank you.
And the other thing that I just I want to express as an opinion, and someone can tell me if they disagree. The resolution mentions that these fees may be used for recreation management. And the need to work on the infrastructure in these areas is there. There's also a need for us to have sustainability in our emergency services, which do experience demand from this industry.
Mhm.
It's my opinion, as I read this, that we're not adopting a resolution that would prevent us from deciding to use some of these fees to help make emergency services sustainable. I want to make sure that I'm not the only one with that opinion.
So, yeah, I wonder what our attorney thinks about that. I would hope that that's true also, that we have flexibility in the use of the funds that are derived from this.
So it's a general fund revenue coming in the general fund, so that would mean it would be a transfer in from the general fund to emergency services, to EMS fund in order for them to use it.
Well, and I think about sheriff's office, et cetera.
Or anything.
Yeah.
Yeah.
The point, if it comes into is there any prohibition on it, on the use of that particular account within the general fund for anything we wanted to use it for?
Philosophically, it makes sense to use fees on the impacts, and I'm just trying to establish kind of a broader set of impacts.
Right.
Lastly, we did receive a summary of a study showing economic impact, indirect economic impact on Clear Creek County from this activity. I just want to share it in public that some years ago, I did a deep dive on what these input-output models are able to estimate in a county like Clear Creek's. The conclusion that I had back then was that they wildly overestimate the indirect impacts of economic activity in Clear Creek because we have so much leakage. We don't have a lumber yard here. A lot of people don't shop for groceries here, et cetera. And so when you look at that number, that indirect impact number of around, it's a big number. It's triple the direct impact. And I would caution everyone to interpret that number with a number of grains of salt.
We've seen that. I've seen the exact same thing. I've had the exact same experience going through the claims of various industries and when they model what they're going to bring to your community. And they often seem wildly exaggerated to me as well on what the benefits are of some of the activities. So just looking at those closely is important.
Yeah, I mean, the rafting community has been a good partner in a lot of ways. They come to the table at community meetings and they're an engaged group. And but I think you make an excellent point. They're not magic. And so we welcome them. We want to help them be successful and continue to contribute in all the ways they do and can contribute to our community.
Right.
I feel like we also want to be able to provide resources to make sure their customers have a safe experience at the various put-in points and while this is not a restricted fund, that these permit fees are going to be restricted to improving those sites, it will help us have a little bit more breathing room in our ability to have more capacity, have dedicated capacity, be able to improve sites, have safe facilities, and well-appointed facilities at put-in points.
Recognizing that we often say things in here that mean something to us because we've been in the conversation so long, but they're not as readily interpreted and understood outside what people can infer from it. I want to be clear that the statement I just made isn't about the rafting community. It's about our ability to do economic modeling and understand how to plan for sustainable economic growth here that actually does what we think it's going to do. So we shouldn't think it's going to do what it's not going to do. And that means that it's on us to do a more professional job of actually analyzing those impacts. When I look at just to be specific about it, when I look at the rafting industry among the different recreational uses in Clear Creek County, it's one that's pretty well contained. You don't see people just rafting anywhere they want to in Clear Creek County. It's pretty hard to go up, off of Highway 103 and do any rafting.
Right.
Up Ute Creek or somewhere, for example. And so it's contained and it's in a place where it doesn't seem to do as much environmental damage to have the environmental impacts. Does it bring crowds to town? Yeah, like anything, which is the only place, if you don't bring crowds to town, you're not going to make any money off of tourism. That's just all there is to it. So it's the kind of thing that is contained in a manner that it concentrates the activity in a place where it does a little environmental damage. People have a lot of fun and we get some economic benefit from it. We should just be really accurate in how we assess what that economic benefit is.
Yeah, absolutely. I mean, they keep the river clean. They do, I'm not trying to cast aspersions on this industry. So thank you for the opportunity to kind of clarify that. I'm not trying to cast
Yeah,
aspersions. on the
I just
industry.
realized it looked like we shot an arrow at the rafting industry. Mine was a general statement about we need to do a better job of understanding economic impacts and evaluating them.
Thank you.
Any other comments? Or
No.
welcome a motion?
Yeah, I move that we approve resolution 24-73, repealing resolution 17-21 and adopting a new licensing program and fee structure for the rafting outfitters.
Second that.
We have a motion and a second. Any discussion? All in favor?
Aye.
Aye.
Aye. Motion passes. Next on the agenda is a choice.
Oh,
Should we push through short-term rentals or should we do a quick recess?
Well, let's go ahead with it.
Next on the agenda is item 3. This is a public hearing. This is the introduction and first reading of ordinance number 19, an ordinance adopting short-term rentals regulations. Peter Lickman is listed on the agenda. We also have Amy Saxon and David Danielson here. Thank you for your work in building this policy. Who should I give the floor to?
To me, please. Thank you. So first of all, this is an ordinance by the Board of County Commissioners of Clear Creek County for the licensing of short-term rentals. We have an obligation statutorily to read that into the record. I also want to point out that a copy of the entire text of the ordinance has been provided in writing to the commissioners. Now I will turn it over to David and to Amy for explanation of the ordinance. After the explanation, that is when the board will solicit public comments.
thank you. So today you have before you a final draft of this ordinance. This draft is open to edits, since this is the first reading. And this reflects, this draft has been before you multiple times. And it reflects a variety of updates and changes. In particular, as you may recall, this is, we've made an effort to, first, we're converting this from a set of rules held in our zoning code to being held in an ordinance. We are expanding and improving the protections and strength of our primary resident program. We've added improvements to fire safety and protection and clarified things related to the responsible agent, to communications regarding guidelines that help protect tenants from some of the conditions of our terrain and conditions around winter driving, and made several other changes. So your job today is to review this document and see if you have any further comments. Is there anything you want to add to that, Peter?
No, thank you.
Okay.
So for me, I wanted to ask the board for a little bit of guidance regarding owner's authorizations and primary resident STR permits. If we were going to allow LLCs, corporations and business entities to be able to obtain primary resident STRs, or if we wanted to limit that to solely owners of properties and trusts for the beneficiary of those trusts.
Okay, thank you. Before we jump into that, I think this is the time to ask for public comment. Correct?
Yes, if there's no additional comments from them.
Comments from.
It's the extent of our introduction at this point.
Okay, that's fine.
Okay. And then we can jump into the policy. So I'm opening up for public comment. Does anybody wish to make a public comment? If you're on Zoom, please click raise your hand.
No one on Zoom.
I'm just gonna hold this open for just a minute because sometimes it can be hard to find the raise hand button. This is an important topic that's attracted some interest in the past. Okay. I'm gonna close public comment.
Commissioner Marlin, just so you know, I'm aware that you had provided a copy with some additional comments. I'm happy to chime in because the first comment that I see that you had brought up, which was regarding defensible space, in the final document that is actually in front of you, we actually had already addressed that. It just isn't reflected in those red lines. So I just wanted, there are situations where you pointed something out and actually
It's in there.
it's in there. In the final nice copy.
This is because I went through the red lines with a fine tooth comb and not the nice copy.
And
So-
but that's on me because there were certain red lines that simply were not reflected in that version.
I don't mind taking the time just to, if you're satisfied, then that's fine. Otherwise, I don't mind taking the time to go through them and just see them if anybody has any. I mean, if the commissioner wanted to do that, I got no problem with checking it out. That's all I'm saying.
Yeah, I mean,
If your curiosity is satisfied, then
I've got a list of things I want to bring up, and I imagine you all may as well, and we might as well start with the first thing that David asked about, which is the LLC topic, and
Can you ask that question? I think I know, I get it, but could you ask the question again? I was cleaning the pad on my.
So it was regarding the use of landowner authorization for primary resident STR licenses. If we were going to allow that to continue for LLCs and business entities, ideally we would allow trust to continue that. But in my mind, the way we've written the regulation, we wouldn't want to allow the LLCs and business entities to still obtain primary resident STR licenses.
Dave, can you point to the section?
Yeah, so it's 6.2 item G, possibly F, depending on the version you have. Owner's authorization. And then there's alternate section where we state in the primary residence absentee and primary residence occupied licenses that the owners must own and occupy. So there's a little bit of a conflict there.
So Commissioner,
Okay.
Section 6.2.
6.2, item G or possibly F.
In the clean version, it's F. In the red line, it may be G.
Yeah, it's G on mine. I'm looking at the red line version. What do you recommend we look at, the red line version?
I actually am going to suggest that you look at the clean version.
Okay.
And I'm gonna frustrate us all because my comments are in the other one.
Yeah, so
Okay, in that case, let's just go with the red line because I have it clean and I can point out if something's.
I'm just so it's easy to follow the conversation with the document.
So David, you said 6.2 G.
Correct.
And then what was the other section?
It was
Primary resident?
primary residence sections for the absentee and the occupied.
And what's the number on that?
1 second. I do not have that up. I didn't,
I know
my
the
Rolodex.
do you need me to?
I know the definition
If you have it.
Yeah,
of primary residence is there.
You have it? I can, trying to find it in the packet.
it's on the red line.
Sorry for the inconvenience.
That's to get the ones charge comments.
You know this better than me, so I might have you find it
There you go.
in the packet. Thank you.
Yes.
I tried to search by keyword, but It's a 600-page packet, so there's a lot of words.
The problem with the
So
LLC,
it's 3.2 and 3.3.
Thank you.
so the problem with the LLC is, this is a question that's, it may not sound like one by inflection here, but, so the issue is that an LLC can own property. The LLC can change hands. There's no telling who owns an LLC, and trying to prove primary residence or prove that the person who is authorized to give permission to use it, if they are, can be anyone who's part of an LLC at that point. And all you'd have to do is have a signature from an LLC, which isn't a person that actually lives somewhere. Is that
Correct, yes. So as I interpret it, as it's been written, is that a business entity wouldn't be able to occupy it. They could own it, but they just wouldn't be able to occupy it.
Okay.
Because there's several owners of business entities potentially.
Right. And so, Peter, was what I just said an accurate description of the problem?
Yes.
Okay. Yeah, I would think we would not then. I agree with that.
And that's in the case of an LLC. We did talk about trusts as well. People often put their properties in the name of a trust, but they live there in that home. So that was a slightly nuance that.
Right. We just did that. Threw everything in a trust. So when when a truck runs over me on my bicycle on the highway, it'll be easier for one to deal with.
Right. Well, and the trust is really for private individuals and not held for fiduciary gain and things like that. So there could be a third party that's a beneficiary of the trust that has no control over that property. So there would be an issue where an affidavit would be written for the person who's the beneficiary of that trust to be able to utilize that property that is essentially theirs as a standard LLC or a primary LLC. Geez Louise, I'm all over the place. Primary STR license. Sorry, guys.
Right.
So let me make sure I got this right. Item G exists right now because it's contemplating, this says landowner authorization if the applicant is someone other than the registered owner of the property. And that is there because it's contemplating an LLC owning the property and the applicant controlling that LLC, right? Is that, am I there, right? Okay.
Yes.
I think it would be a mistake for us to say an LLC owned property can't be eligible. And that's because it's very common for people to have the property owned by an LLC for liability protection. It's kind of a base need of that business model. And so I think we need policy that allows for that.
For the standard and the primary?
I think if someone, as a resident running a short-term rental, my home was not owned by the LLC, but it probably should have been.
Right.
Tried a weaker attempt at protecting my liability, and now that I know more about the law, I may have done it differently. So I think we do need to allow for this, and we need to rely on making sure there's actually an occupant in the home, like that section of the policy, to make sure we're not creating a loophole in doing so.
Well, the person who is the occupant needs to be the person that's getting a primary residence permit, or they are by definition excluded from being able to get a primary residence permit. So the applicant and the primary resident should be one and the same. The owner of the property, I can understand that legal distinction where someone has, for liability purposes, titled the property under a different name. The catch, and this is kind of apart from that, is that it's also problematic because, as we've seen in ownership of other kinds of rental properties where people are renting it out, they have LLCs that own the property, and we're trying to monitor their activity and how they're operating that property. And they sell the LLC and we don't even know about it because the LLC, because the property owner doesn't change. The property owner is the LLC. They sell their LLC to somebody else owns the LLC out of New York, and we don't even know what happened. We have no way to know it because it doesn't show up in our assessor's records or anything else because the property technically didn't change hands. The owner of the property just removed the human body out of it and put a different human body in place without anybody even knowing it.
Right.
And so it's a different person that now owns the property, but we don't even know that. So that's the problem with LLC ownership and trying to execute these kind of regulations, I think, is understanding, even being able to keep track or prove who owns the property.
Well, one approach that could address that, Randy, is if applicants are always individuals as opposed to entities.
That's what I'm getting at. And so therefore, the applicant's an individual.
But the owner could be an entity.
And that's the role of the landowner authorization form.
And I think I totally agree with this risk. And I think where we're trying to address this in the policy is in 2.73. This is where it talks about transfer to a limited liability company if the original applicant doesn't maintain a majority interest in that limited liability company. They may not reapply, or they have to go back to the waiting list. And
So you got to prove that you've got a controlling interest in the LLC
right.
each time.
Annually, yes.
That
I would
helps.
say membership or controlling interest as a member in an LLC should satisfy that.
If you say or controlling interest, why even have the or controlling interest in there if membership alone is
So I'm
satisfactory?
thinking, for example, of a couple that's married and each may have an equal interest as a result, but so it's two people. I would say they still have a controlling interest over maybe the children that are in there or something in the membership. It depends on how the LLC is formed. So if you would rather just say membership in an LLC, in the LLC, I think that's fine too. But that may not be specific enough.
That feels too loose, right? Because
Yeah.
I could own 1%.
Yeah.
So if we put controlling interest and the documents are presented and you have a married couple present, I think it's then up to staff to make a determination of whether that meets the criteria, understanding the intent of the board, which is not to have 10 people, members, all have interest, but obviously perhaps the purchaser of the original property that went and converted to LLC. I think staff can probably make that determination. So if we put controlling interest, then that would be my thought. I think we understand the intent of the board.
Mhm.
Controlling interest is more restrictive, and then if staff ends up believing that whichever individual, whether it's the husband or wife or whatever, does the application, I think they meet the definition.
I think the controlling interest has to be demonstrated in some form, because otherwise I think it's really weak. I mean, if we want to address George's concern that an individual has the right to try to title their property in a way that reduces their liability and is fiscally responsible to themselves, that's great. And if controlling interest isn't good enough, then that's where they're starting to get kind of outside the intent of what this whole thing is. If you don't have controlling interest in the property, then it's not, then do you own the property? And you do in part, but I think if there is an LLC, then the LLC needs to be able to demonstrate, whoever the person is representing this, is that they are the primary resident of this property. And secondly, that they're not, that you're not one of a giant partnership of people buying up a ton of, I'm thinking about the St. Mary's model, where there were people coming in from out of town and buying up several of these things and then dividing up, each of them claiming, a few partners get together, buy a few properties, and then they kind of dole out the names, across the property so that each one has a primary resident, and they all live back in Illinois in some town,
And that may address, so a hypothetical that we have talked about is, for example, the owner of a property, the one that purchased it, lives in Canada, but he formed an LLC, put it into an LLC, and his children live full-time in the short-term rental.
Mhm.
Do we say no because he's not a primary resident? He lives in Canada.
But the applicant should be the person living there.
right? Which would be the children's home. But I'm giving you an example that it may all be in the parent's name, but he only owns the property. So what are your thoughts on that hypothetical?
I hesitate to open up this can of worms. My thoughts about how to do this are to allow renters to negotiate with their landlords so that they may operate an STR business with the landlord's consent. And I know I brought this up and I know the board has disagreed, and I'll just say it one more time and I'll be as concise as possible. If you work for your money, it's pretty tough to get by these days, and business opportunities should be maintained for people.
That's the same argument that a lot of people made up in St. Mary's that lived out of state. We need the money.
Yep. And I think there's an important difference between living out of state and living in the home.
I think it's a reach taking Peter's hypothetical and assuming that the non-owning generation that's living there actually has a lease. But I'm not gonna quibble over that.
I generally have the same feeling about I won't be around much longer to talk about it, but I haven't wrapped my head around, been able to wrap my head around the idea of renters renting properties and then renting them out as short-term rentals, subletting them out as effectively you're subletting out your property as a short-term rental for part of the time that you live there as a renter from somebody else, and that's part of your lease agreement. And part of me says there's nothing wrong with that. I'm thinking of myself as a young man raising my kids and, crawling home at night, chopping wood and stuff like that. All, put myself emotionally into that picture again. Yeah, I get it, man. I can live in that body and still be that person and remember it. I can also see people in the modern world building complete business models around that with smoke and mirrors, so I'm kind of caught in that tension between the two, knowing that there's not a loophole that you can't find a way to drive a Mack truck through if you know how to drive.
It's true that you only get one primary resident permit per person.
That's the limiting factor.
I think the concern that was raised by the county attorney that was persuasive to the board when we first discussed this back in May was one of enforceability. You've got a renter that's the applicant, yet it's the landowner that you could have to enforce against. And I would argue to you that allowing an LLC to be the landowner while an individual is the applicant is the same situation, and this appears in the document without that concern. And so I don't think that there's consistency here, and I think this lack of consistency in this case is harming renters.
So, Mr. Chair, I would ask if you could inquire as to what staff recommends as the solution on this. Because there is an ability to manage this different ways, and one is more realistic and more considering our staffing levels, and one is not. So
It would be the staff's preference that we would allow trusts to utilize a landowner authorization for the primary resident STRs, and that LLCs and business entities would be excluded from primary residents and STRs because it creates a conflict with the intent of the ordinance.
Mhm.
In my eyes.
I believe I agree with staff on this one.
How many currently licensed STRs are owned by an LLC that would be rendered ineligible if we make this policy change?
I can't give you an exact number right now, but I can get that to you later. There is a number of them.
Is it more than zero?
It's more than zero.
I know that this board has had a policy in the past of not trying to pull the rug out. Made investments in a legal way to create a business.
We also require renewal of the license every year. And for any number of reasons, people can become disqualified if the situation changes, but I understand, yeah, grandfathering somebody in that we've allowed to get into a situation is one thing. We don't allow, for example, in other cases, we don't allow people to transfer their license on the sale of the property. That's also a place where we can argue that they've made an investment in their property or in their life, their business model or whatever, that they now are unable to derive equity from when they sell the property in the value of the property. So we have other things that are just the results of the intent of our policy and the way we've written it to try to achieve that intent.
I'd like to hear the staff recommended approach one more time.
So the staff's recommended approach for primary resident STRs would to be allow for trusts to use a landowner's authorization for the beneficiary of that trust to be able to utilize that property for primary residence. But then business entities, LLCs, corporations, Incs. Would not be allowed to obtain a primary resident STR license.
And it would be a beneficiary versus the beneficiary because there could be multiple beneficiaries.
Correct.
Okay.
I don't want to wax too philosophical here. I think, we all expressed a desire for economic development. That's an expression of a desire for the people of Clear Creek County to be able to thrive economically. And it's very important to me that that opportunity is made available to you. And when we start going down a path of saying this is going to be difficult for staff to administer, and so you just can't get a primary permit because you've put this under an LLC to protect yourself, we're harming the economic outcomes of our people, of the people who live here, our constituents.
Peter, can I just ask if, how much change can we make to this draft and stay on schedule to get this ordinance passed in this calendar year?
We can make significant changes
And so,
today, and then when we bring it back for second reading, if there are additional changes, then we make those, and then it passes, subject to those changes.
Okay.
To a motion.
okay,
So we're okay.
okay,
So this isn't a matter of just waiting till I die so you can pass the thing. I just want to be, I would like us to have a cogent conversation in which we talk about our intent and resolve our issues and get the problem worked out. And I want to be clear that my thought isn't that the specific example that George is describing where this property owner is the LLC. They own 100% of the LLC, or they're 50% of it with their spouse or something like that. That kind of a real world situation in which they've simply done that. There should be a mechanism through which they can do the same thing that anybody else can use to have a short-term rental there. I do believe that. The catch is that how you can do that in a manner that doesn't allow someone else to game the system, or some other group of people, I should say. Because if it's one person and they're living there, they're not gaming the system, they're living by the rules. But if it's a group of people that are gaming by whose name they put on the thing and what paperwork they turn in, and they're just, like I said, driving a Mack truck through a loophole.
Yeah.
I just want to know that we somehow put words in this policy that allow, that truly restrict it to that couple or that person. A couple of partners or a person who are creating that, as opposed to a more business and economic development. I'll steal those words back, model that does that. I mean, part of the same argument that people gave to not even have short-term rental regulations is the one about we need to have an economic future and be free to build that future. And we shouldn't have restrictions of government from keeping us from doing this. But part of our economic development model includes having housing for people, which is why we do have short-term rental regulations. So at some point, we can't have our cake and eat it too, but we should be able to design the cake so as many people can reasonably eat it as possible, as long as we're satisfying the intent. So a couple living in a house titling their places in LLC is one thing. How you can write that so that it doesn't just open up a larger can that somebody can take to court, for example, and say, we're not being treated, we're violating the 14th Amendment or something like that, I would just like us to know that we've written words in the final document that restricts us to just exactly what our intent is.
So, and that's a really good point. In the whereas clauses of the resolution that my office had drafted, we address both the economic development aspects as well as the negative effects of STRs. In our purpose section, which is 1.2, we go through some of that, but I think it makes sense to perhaps even further define that intent so that it informs other interpretations, and that allows staff to make some of those decisions so that clearly if somebody has 10 people in an LLC, staff can address what the intent is, which is not to allow abuse of the policy.
Well, yeah, just so the words of the regulation satisfy the intent.
I want to just add to that. I think the staff recommendation is not, I think it's an oversimplification to talk about it simply as administrative ease. It also does align with the purposes of the primary and short-term and standard short-term rental programs. The primary program is designed for individuals who are a little bit more on the cottage industry side of the short-term rental industry. This is the vision of it anyway, right? So that a trust does line up better with that as that particular tool. As that's the thinking, right? It's not merely this is easier, right? It's how can we use this type of different ownership model and have an organizational device for the complexity around it that lines up with the way the programs are. So yes, that does simplify things, but simple isn't just to make it easy on staff. It makes it easier on applicants. It makes it more logical from a variety of perspectives. So I just wanted to throw that into the mix to this conversation because it's not merely just a crass desire for staff to have it easy.
I am certainly not trying to cast that aspersion.
Yeah, and I never even thought about staff time. I just want you to know, I never cared about you once while I was thinking about this.
That makes me feel so much better.
I just want to do it right, and then you're just going to have to deal with it. That's my take. So. I'm sorry. I didn't wait for you to
No, that's okay.
acknowledge me.
It's fine. We're all good. I like adding some purpose in here. As a way to make this work better, as a way to make the definition in 2.73 more workable, right? So that if staff comes across a situation like a married couple that doesn't trust each other enough to say, I own 51%, you own 49%. Then like I'm fine with that. I think that's a reasonable solution. I think that leaving 6.2F as is now I understand why it's there. And I think leaving it in there makes sense. And then the last one was 1.1B, right? And that was related to this. And I just want to go back and look at it. Oh, right. 1.1B is where we go out of our way to say, you can do this. The only context where you can't do something like this is if you're renting a home. All right.
Oh, you're looking at, okay, so in the red line, it says you're referring to primary residence?
Yeah.
Okay. So in the red line, I believe it's 1.1D.
I concur.
1.1D, you're right. Sorry. So we can find a way to, and if the board is good with this, the board is good with this. We can find a way to have it so that if you own the home and you transfer it to if you own the home through an LLC that you can control, we're not worried about the enforceability. But if you are in a lease arrangement, we are. And that's the only, in my opinion, the only thing that is outstanding here as
Mhm.
a problem. And that's just my opinion, and I'm gonna leave it there.
Can you state that again, George? More concisely.
Yeah, I
More
mean,
with more brevity.
I'm gonna do my best. It seems to me like we're allowing a person who owns their home to create an enforceability issue, and we believe that we can overcome it. We are not allowing someone who rents their home to do it because of that same enforceability issue, and we don't think we can overcome it.
And we're just applying the same thing in the LLC environment.
Right.
You can't use an LLC ownership to shield you from the tenant issue. Like, you can't just lease from an LLC and then be allowed to apply.
I guess your point is that whether you're the titled owner of the property or not, you're either cheating or you're not cheating. That's the bottom line.
Right, exactly. And if you're a renter and you're able to, and good luck to you if you're trying to convince your landlord to let you run a short-term rental, but if you can, I can't think of a compelling reason to try to prevent that. And I think we're talking about something that's not very likely to happen, which is why I haven't jumped up and down more than I already have.
You mean you don't expect many renters to come in applying for short-term rental licenses?
No, I mean, everybody here, when we were having the original conversation that owns a home is like, well, I would never do that with my home. And I imagine a bunch of landlords are like that. I happen to be a landlord that would.
So because
That
it's something
has.
we would never do, we should encourage it.
Well, but isn't it, it's precluded.
Correct.
Yeah.
It's currently precluded. And
And it sounds like it's staying that way.
I don't hear you or you saying that you want to allow for that. So I'm going to stop talking about it.
It's been a fun conversation.
So did we solve that first question?
Yes, I believe we did.
Second question.
Peter, you told me it might, well, Mitch, let's go to your comments that you have.
Okay, I accept. David included a comment about prioritizing residents of Clear Creek County, and I'm curious what other people think about that. As a analog to having distance restrictions.
You're on page 5.
Yeah, this is in
What's the
section
one?
4.1. Talks about the waiting list.
And distance restriction.
David's comment says, instead of distance restrictions, should we consider, just making county residents a priority in licensure?
Page 5, section 4.
It's not in there now, and you're suggesting we add something that prioritizes local.
David asked the question, maybe he should be the one presented to us.
Yeah, so in the last work session we had, there was a proposal for a distance restriction between absentee STR permits. And we're creating a waiting list on a first come, first served basis in lieu of, say, a distance restriction between STR licenses or absentee licenses. We would give the preference that the individuals who are Clear Creek County residents would go higher on the wait list. So individuals that were receiving absentee permits would be county residents and have an invested interest in our community and the homes around them.
If you can do
So
that, go ahead. Sorry.
And I saw what David's comment was. And I do not believe that we can do, well, I know that we cannot do that legally. We cannot discriminate between those out of county and those in county. on that basis since we provide for absentee standard licenses. The distinction is the benefit we give people is those that are primary residents, therefore residents of the county, get that type of license. Regular STR goes to the absentee. We could create two separate waiting lists if you wanted to do it that way.
My
That
question,
automatically would give primary residents the ability to carve out the absentees from that waiting list.
Create a
You
Clear
have-
Creek County resident waiting list.
Yeah, because what you would call it is a primary resident waiting list versus the other standard license waiting list.
I don't think,
We don't need a.
we don't need,
Oh, right, because there's no cap.
so, okay.
Okay.
So we can't do it.
We can't discriminate between those out of county and in county.
We can't
in terms of
prioritize
that.
county residents on our absentee and our absentee program.
That's correct.
Okay.
I don't think there's that big of a moral reason to do it anyway, or I mean, we want to be nice to the people in Clear Creek County, I guess. But if they are a resident of Clear Creek County, that means they have a primary residence somewhere in Clear Creek County. That's by definition, right? But they're asking for a non-resident, non-occupant license. And so at that point, they're kind of entering a pool where they're pretty much the same as somebody from Illinois. They're owning property in Clear Creek County in which they don't live, that they would like to rent out on a short-term rental basis, which pulls it out of the long-term rental pool. So functionally, in terms of benefit to Clear Creek County, the idea of, first of all, I think the need to do it doesn't seem to be that great for me. And then secondly, I'm trying to think about how do you manage a list that you say you get in line in the back of the line, and then you have special people that can come up and get in the line in front of you anywhere they want to, and not only that, but how do you exactly, what's the trigger that you pull? What's the threshold that you cross? What's the thing that they provide? And then where do they get in line? Do they go to the front of the line? Do they get in the middle of the line? How do you execute it? It's going to be a hard one.
Well, I mean, so those are very relevant questions. And I mean, I do think programs are generally one may be able to argue that the programs are different enough that maybe you could consider, maybe there would be a way to say that they're different enough, that it's not it's not the same, that just because you're eligible for the primary resident program, that you might still want the standard STR license. But the other thing is I'm not sure that does the same thing as address the initial concern, which was about distance and providing a way to a space between the permitted spots.
Yeah, thank you. I mean, we heard a couple of public comments when we first discussed this, right? We heard a public comment from someone who lived in a cul-de-sac who has become the only resident on that cul-de-sac. So she's got like Lynn Auto, and she's got like 4 or 5 neighbors, except she doesn't. And then we heard a comment from someone that lives near the top of Witter Gulch who had the same scenario. I see staff saying 0.2 mile distance would severely limit the number of homes. My feedback would be, is there a distance that would not?
So that was my question, is that if we can't create a priority list because it discriminates against individuals who live outside the county, can we provide a distance restrictions? Because then we're discriminating against those who are within a quarter mile of another absentee permit.
So you can.
Yeah.
Because by putting that restriction in the regulation like that, you are arguing essentially that you can rely on your public safety health aspects of making that determination of not creating a neighborhood of empty residences, except for one. So that's how you would focus. The additional thing is that if you have, typically speaking, if you have owner occupied primary residences, it's going to be regulated a little more than if the owner's out of state but has these other standards, isn't there to monitor the parking, isn't there to monitor the traffic, how many cars show up. And so you could set that so you absolutely avoid that situation of having one residence where somebody's living and then 5 all on the same street that have a vacant owner. And so that is not discriminating. That's not saying out of county, in county. That is saying all distance related, and that's a definite legal basis to make that determination.
Because it's a density of a land use as opposed to a distinction of a person
That's
carries.
status. That is correct.
You can argue that the distinction they carry is that they, we just talked about resident, non-resident of Clear Creek County. And, not being able to discriminate in that fashion, but that residency is only caused by where they choose to live. And the same is true about being within a quarter mile of a place. So I'm just playing the devil's advocate because actually I like the idea of reducing the density of them. And I thought I might have been wrong. I may have misunderstood as George described it. I actually thought that Lynn Otto and this other fellow were very close together, and they were about the only 2 people that were left. And and because I thought his letter said that now that Ms. Otto is selling and leaving, I'm the last person standing in this area up on this road. And everyone else, and the people that will buy from her will put in a short-term rental. And now there will be no one up here, but I'll be the only one the only local in town, basically.
I might have been wrong. In that
And me
characterization.
too. Yeah.
So I mean, I think this is a problem for us to solve. If we don't solve it in this ordinance, we're going to hear about it the next time we're trying to do this. My suggestion is to ask staff to come up with a distance that wouldn't severely limit the homes.
And to put it in the next draft of the ordinance you see, I think we will take a stab at that. I want to just also comment that, as I was just thinking about how we would implement this, most of the new applications that we are getting, since our short-term rental program tends to be full, and we fill those slots through waitlist churn, are primary resident applicants. And I am hopeful that the changes we are making to the primary resident program may mean that, Peter, your characterization of the primary resident permit holders going forward will be those owner-occupied primary resident permit holders instead of primary resident permit holders that have gamed our system a little bit and are not actually owner occupied, which I think is currently the case in our primary resident permit program right now, which is part of the reason why we're doing this work right now. So I think yes, we will do that, and I think we will be seeing some improvements in the caliber and impact of the new permits that come online as we move forward with the changes that we're making in this program. And I'm optimistic. Will it be magic? No, it will not, but and that's the second time I've said magic at this table this morning. But that is something I hope will help.
I do have a question for the board. When we determine this, let's say we reduce the mileage, but it essentially keeps 5 people on the same street from having STRs. We currently might have a situation where we have 5 people on the same street with STRs. Does the board want to allow in the ordinance that currently existing permits will not be, when licenses are issued, they will be allowed to apply for those licenses if they had that pre-existing permit?
To be renewed.
So that they are not hurt financially or anything from that standard.
Yeah, we should create some kind of a non-conforming legal use.
Okay.
If you currently have a license.
I mean, that they have to meet the new criteria if they are a primary resident permit holder, though,
Right.
in particular.
We are not creating a non-conforming legal use around getting a primary license in a home that you don't actually live in.
Yeah, that's the key. I mean, there are 2 things coming here. We know we have a bunch of people out there that are gaming the system. I'm positive of that. The question is, how do you confirm that non-compliance? And then the second one is, how do you execute the disqualification from being able to operate any further? The second one is kind of easier unless they just decide to keep robbing banks, and if they can get away. And if we don't find them, but to operate. But the first one is a little more difficult. And these regulations are taking a step at that, but they're not magic either. We're gonna, we have to have the staff time and a system that is pretty effective at doing the detective work and determining because we're hearing from people that are sending us emails saying all of these people out here around us at these addresses are doing this. Now you got to go prove it.
So are we in agreement that we're gonna ask?
Finish your sentence.
Are we in agreement that we're gonna ask staff to come up with a distance that they think isn't unreasonable?
I'm willing to do that, but I'd point out that we have large lots and we have small lots within our community. And there are some private roads or county, non-maintained county roads where you could list a couple hundred yards and everybody in the neighborhood could still have a permit and there'd still be that one person that's isolated and has no neighbors. So.
Perhaps the better way to look at it is density.
So I think we're putting, I think it's gonna be a real challenge for them to pull something together that works. I'm not saying don't ask them to do it. I'm just sharing that, density is a tough way to keep the neighborhoods from being empty.
I mean, I think we can take this direction and see what we can come up with. I mean, I think what I'm hearing is that it's density, but it's in context of the different neighborhoods and with the goal being to try to balance the negative impacts of the neighborhood getting kind of out of balance with un-STR'd homes and I'm going to say regular, but that's not what I mean. Like homes that are occupied without a STR permit in place, so.
Some just struck me as really funny that people don't want to live in town, so they go out to live in the woods where it's peaceful and dark. But I guess it can get too dark.
And the impacts of a policy fail here are more acute when there's more density, right? So,
Yeah.
but I'm good with your comment. If staff has a different distance or just a different approach, I would love to see us try to do something here. And see where it goes. And I think the board is in agreement. And so, Mitch, should we keep going with your list?
Sure. Just going to bring up another one of David's comments. It's in section 5.1E, I think, 5.1D, and it deals with notification distances. And it kind of tags along with what I just, mentioned. So David, can you share your thoughts on that?
Yeah, so there was a ask from the BOCC to increase the notification distance when an individual is going to have an STR for the 24-hour contact person. So staff believes the increase of 300-foot notification distance is adequate. The Planning and Building Services Department plan to proactively educate the public and county residents how to use our interactive maps and to find those responsible agents themselves.
Thoughts?
A football field worth of distance seems adequate.
I can live with that too.
What's that? I can't hear you.
The question is 300 feet.
Yeah, 300 feet football field. Yeah.
Are you good with that?
I just didn't hear your words in response.
Oh, I said
to
I'm good
Mitch.
with it too.
Oh, yeah, I think so. Yeah.
Just to build on what Dave said a little bit, we plan on making sure using things like the STR dashboard and some proactive communications that it's very easy to find responsible agents for people so that they can contact and ask questions and, that's an easy thing to do. That's at the thing, let your fingers do the walking.
Okay.
So 7.1G talks about fire and smoke detectors and fire extinguishers. I'm just curious if we should pull from some fire department best practices when we talk about the fire extinguisher. It describes it as operable, but how do you measure operable? And also, where should it be? As written, I could put it in the back of the utility closet and comply, but my visitor's never gonna find it in time to do something effective. So I'm just thinking maybe the fire department could help strengthen the fire extinguisher conversation.
Yeah, I actually have the Evergreen Fire Protection District on this specific item. Cleared it with them, made sure they were satisfactory with the specific fire extinguisher that we have delineated here in the regulations. And then the location of that fire extinguisher will be required to be moved if it's somewhere inconvenient or inaccessible at their safety inspection. So we'll instruct them to have it mounted on a wall or possibly underneath the kitchen sink or something like this.
Okay. In commercial operations, they need to be inspected or certified at some sort of frequency. Just the word operable bugs me, because the only way to tell if it's actually operable is to use it.
Yes,
Then it's too late.
so we could require an annual inspection. That's the standard regulation for fire extinguisher inspection. So
Which would
Don't
mean
jump
that,
on it just because I said it. Listen to these other guys.
which would mean that basically upon renewal of your permit, you need to show that the tag on the extinguisher is not expired, and otherwise we don't have any way to really, that's as good as we get, probably.
David, you already include annual inspections, don't you?
yes, annual inspections are required of the STRs.
I mean, I'd love to give you some teeth and actually write in there that it needs to be visible.
Yeah, I
I
mean, unexpired
don't have a problem with
certification,
that.
that kind of
I was
stuff.
just trying not to tell them what to do.
We don't mind the direction. We don't. I mean, that's fine.
And
It helps with the worry that David has on his face about all the things that are being said right now.
No worry, we can take direction well.
All right,
anything else?
not on that topic.
Think of them as guidelines. Just
I think 7.1J talks about garbage. Just curious if we're over specifying what a bear-proof garbage can is by saying it needs to be a heavy duty steel enclosure. I've seen a lot of allegedly bear-proof trash cans that aren't steel. So just throwing out, I wonder if we're over specifying
Steel.
by saying it has to be a steel enclosure.
Is anybody aware of any standards for what makes a bear-proof trash can? I guess I can do some research
We'll
into
look
that.
up.
And we will possibly provide a definition of bear-proof.
I'm sure there are standards because there's some communities that outright require them for everybody.
Georgetown is an example.
Yeah, what size beer?
I hope Idaho Springs.
And species.
We don't got to worry about the polar bears here. All right.
Polar bear enclosure.
They gotta be reasonably, approximate to where we are.
So 7.10 in the markup talks about fires and open burning, and buried in there's defensible space. I heard there's a parallel document that might talk about defensible space requirements in more detail than the markup.
Yes, so we've included defensible space in the definitions in the red lines, and we're going to reference the building code and then the Colorado State University bullets number 6.302 or 3.602. I can't remember which now. We'll reference those documents to determine what defensible space is and how it needs to be established at the residence.
All right, so someone who might have done their last construction 30 years ago and has outdated defensible space, if they want an STR permit, they're going to need to upgrade to the current standard?
Correct, yes.
Perfect.
And the language that's not reflected in the red line, but is in the final version, does note that those things are amended from time to time. And so.
Okay.
Because even the Colorado State University fact sheet has been adopted by another entity that says it replaces it, but it's the same document. Just to cover it all.
Thank you. I had that comment. As far as the question, David, should it be its own requirement outside of fires? I mean, my sense is yes, but I don't have a strong opinion on that one. Sort of just in terms of document construction, I wouldn't mind people seeing that.
As its own line item.
Yeah, it's just, it might help applicants not get caught off guard as they try to understand what they're getting themselves into.
Okay.
On fires, you mean like,
Just on, like, right now, we refer to dispensable space in the section on fires, and it could just be its own section. And that's the question that David asked, and I think it's a good observation.
So 7.1T in the markups titled limitation of liability. And the fourth line down says owner shall maintain appropriate liability insurance. And I'm not sure how to measure appropriate.
That is not shown in the red line, but if you look at the final copy, you'll see I specified exactly what we are expecting, including bodily injury coverage.
Okay, great.
Things like that. And I reference it to another section as well.
I mean, my chief and maybe my only concern, the only one I can think of is that if there's an impact to a neighbor, that neighbor has, a turnip to squeeze. Right? Like there's cash available for that neighbor to go and get if, for example, their home gets burned down by a short-term renter operator. Bodily injury seems a little bit outside of that scope of my concern, but I don't.
So it's not just, I was using that as an example. It's general liability as well that we address, as well as theft and related things. Whether or not you will finding insurance, even short-term rental insurance, to cover damage to another property is kind of like your homeowner's insurance being responsible should your home catch on fire. It's difficult to insure for that.
Okay.
So.
Should we move on?
Yeah, I think, George, I'm gonna get to my last one here. Is it clear that short-term rentals can't operate during an appeal process?
During a what process?
An appeal process?
I don't know.
So my interpretation is yes, but if you have a question when you read it, that leads me to believe that maybe we need to make it clearer. Because what happens is either the denial of a short-term rental license or the revocation is immediate. And so were they not to comply with that during the appeal process, it continues to be repeating violation in the county's view. But I don't have any problem just adding a sentence saying
You cannot.
cannot operate during an appeal.
You guys okay with that?
Yeah.
Mhm.
Okay. Tag, someone else's turn.
A lot of what I had has been addressed. Let me just scroll through here.
So the board knows there were probably 4 Scrivener's errors that we did find in the final version. So if you happen to see if some of them, we've caught them most likely. And we will go through it again, of course.
Let's see here, page 6, section 5.1B. It reads, in the event of a fire ban within the county, the responsible agent is required to be registered with the Clear Creek County Alert System. I think this registration should just be required. I think the responsible agent should just be registered with the Clear Creek County Alert System. There's lots of different alerts that might help save the life of someone inside that structure. You must be,
Okay.
If you're not
I just
registered.
think that you just must be registered.
Good point, I should say.
So otherwise, obviously, I'm good with the rest of it.
Okay, thank you.
So how do we know if someone's registered?
Thank you.
I'm just curious. Do you have access to people that have registered? Or is that held by a third party and we don't see it?
Jeff.
So that's something I'll have to look into and I'll have to get back to you, gentlemen, with that information. I'm not sure if we can check that internally or if we'll have them prove that in another manner.
I was just curious.
Well, are you talking about fire bans and stuff like that?
Yes.
There is a email/texting list that they can subscribe to, and I can check emails on there too. So if you have their email, I can verify that they're signed up for that.
I think what we're talking about is,
To verify it to us.
Then that's totally
Yes.
fine, but yeah, I'm just letting you know that we
Yeah.
do have a dedicated list for that.
Yeah.
but that's the non-emergent system. We're talking about lookout alert.
Oh, I'm sorry.
Yeah.
Okay,
Um, They should be on that one too.
okay, yeah, no worries. I was just
I mean, I
saying
don't-
it's an option.
I don't know that we need to require it, but recommend it, right? Okay, this is an observation. My intent isn't direction. Page 8, item F, I guess that's section 7.1. We define guest load. We also defined guest load in the license types section, and it might be a little redundant. It might create some kind of an inconsistency, and that's just a comment for you guys to take a look at. I don't.
In light of the numerous revisions we've done, it's very possible that certain portions that we moved to other areas were still kept in some areas. We can double check to just to make sure it's not
Yeah.
redundant.
Thank you. Page 10, paragraph U, I guess that's section 7.1. Posting of information. Two things. We require a guest book to be assembled, but not to be posted.
We'll provide specific direction on where it needs to be located within the STR,
Or just that it is,
provided,
And-
just generically provided in the STR.
yeah, whatever, policy you think is, whatever language you think is right there. It just seems like a missing thing. And then, this probably isn't functional, but I know like those guidebooks are now like available in the booking service, and often booking services will require you to read it and acknowledge it before you book it, and that's great. And they probably will do that anyway. And so I don't know that we should require it because maybe they're using some kind of platform that doesn't have that tool. What I would like to see us do is require advanced delivery some way of this guidebook. There's information here that people need to know before they arrive, right? Like this is on a 4-wheel drive road.
Right, so I think we've addressed some of that in the good neighbor guidelines, which are required to be provided before their arrival.
Oh,
As distinct from the guest book, which
Yeah.
maybe include physical copies of things from local restaurants and things, which would pose some more challenges to
And the guest book
digitize.
does require, the guest book must contain the Good Neighbors guidelines in addition to all that other
Okay.
stuff.
that's good. So do the good neighbor guidelines require information about the state of the road that the short-term rental is on?
Yes.
Okay. And is there anything in the rules right now about notification of inclement weather? Occurs to me that one of the things that would be a real service, and I'm thinking about St. Mary's right now, is if you're about to land in Denver and there's a snowstorm, that your host says, hey, there's a snowstorm. And you might want to think about whether you're renting a car that can get you up this hill.
So in the good neighbor guidelines, it was recommended to check your weather conditions in advance and plan for alternate routes and alternate housing.
That's good enough. Okay, thank you.
Does it recommend, it could be a general statement for all of Clear Creek County, which is it's recommended that you have an all-wheel drive car with, not required, but you can't require people to do that, but that it's recommended that you have an all-wheel drive car with, all season tires in the winter time or something like that? Is there a statement, anything like that?
Uh, I'm not 100% sure on that, currently. I know there's
know if it
recommendations
should
for
be,
four-wheel drives and all-wheel drives and to check inclement weather, but I don't know if there's just a generic suggestion to provide a four-wheel drive in any weather condition.
I don't drive an all-wheel drive car. I don't know.
So Peter, I don't see that the STR guest guidebook actually includes the good neighbor form.
Item XIII, very last one.
Oh, because it goes to a third page. Sorry,
We put that huge space just to
That, you know.
confuse you a little bit.
it worked. Thank you.
Missed that too. Okay. I don't have any other comments. Unless you guys want me to start talking about renters again.
No.
Okay. Any other comments from the board?
This is a huge body of work and
Yeah, it is.
it's really going to benefit our citizens. So thanks.
It's been a huge body of conversation is that we've undertaken to put in front of you too, and I appreciate your responsiveness. And I think it is making a better program.
I would just offer too, this is something that we can continue to improve upon. And at some point, I think, we will need to allow it to move forward and just see how it works, right? And then we'll be able to come back and do more changes as well.
Yeah, it's
And I
a
think-
living document.
Yeah.
I think the three of us are committed to getting it on the books this calendar year.
Yeah.
So you'll get your move forward and see what happens.
Thank
time.
you, Mitch.
My goal is not to find anything else, right, with this. But I am gonna read it again.
There are two more housekeeping things when
You don't seem to be very goal oriented. If your goal is to not make any more comments, but you're gonna read it one more time, it's like, that's.
So this ordinance, once passed, would take effect January 1st, 2025. I believe that's okay with staff, so that's done. I want to make a comment that I have been really appreciative of David's work and Amy's, but David's work in particular on this, as he started his job and revised the short-term rental ordinance, is working on the building code in addition to managing the code enforcement and professionalizing that. And I genuinely appreciate his work on that. I'd like to request the board order the ordinance to be published in the Clear Creek Current and the Canyon Courier, and request that the board set December 17th, 2024 at 8:30 as the date of the next public hearing to adopt the ordinance.
Anytime after 8:30 on December 24 is okay, right? Does the motion need to include with direction to bring these modifications, or that direction is already established?
The direction's already established because we will make the revisions before it ultimately gets published in the paper.
Yeah, I was just gonna say, I appreciate it, and I presume this will come back with the comments incorporated to which we agreed.
So moved.
I got it.
Second.
Motion and second, any discussion?
No.
I'll just share, Amy, we have long been appreciative of your efforts and we do see a big difference in David's efforts compared to what we've seen in the past. And thank you for acknowledging that.
Just to balance this, I'd like to say, Amy, this is phenomenal work. And yeah, Dave, whatever. Just to,
Awesome.
Thank
Motion and second, all in favor?
Aye.
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 Motion passes. Housing Authority Agreement is next. I think this is the right time for us to go into a brief recess. How much time should we take?
I need 20 minutes, something like that.
Okay, the board will reconvene at 10:50. Okay. Okay. We are reconvened. This is the Board of County Commissioners. The next item on the agenda is consideration of the Creek County Regional Housing Authority intergovernmental agreement with Amy Saxton. You are back.
Back. Yes, Commissioners, today we are bringing to you for your consideration an intergovernmental agreement for a multi-jurisdictional housing authority. This is a fairly fully fledged document. This has been approved and adopted by 3 of our 4 fellow municipalities, Idaho Springs, Empire, and Silver Plume. It's still being considered by Georgetown. This creates, this is an agreement to form a multi-jurisdictional housing authority, which will give our community capacity and certain authorities to advance affordable housing in Clear Creek County. The partnership, where each of the towns contributes some funds so that we can form this organization, endeavor to create more specific strategy for that organization, hire an executive director, and work to advance affordable housing, provide resident services, identify any revenue streams that might be appropriate for the organization, and make some real headway on providing more affordable housing for our community.
Thank you.
And is your ask for the day that we approve the IGA?
That is the ask for the day. Yes. Thank you, Mitch. Commissioner Houston.
I think there's, as I read the memo, there's a separate ask, which is for some direction about what to do with the Clear Creek Housing Authority. Not that we need to bring that up first. Do we have questions about this IGA?
Mr. Chair, I'll add a third item to that is how you want to, do you want us to bring back a separate item to appoint someone to serve on this, et cetera? So kind of next steps coming.
Thank you. I know that this document has gone through review by us and our municipal partners in the mayors and commissioners meetings, I think a couple of times. Because 3 of our partners have already adopted it.
Mhm.
In the form it's presented
In the
here.
form that it's presented here, I'm inclined to approve it in that form today.
And I think like the last topic we discussed, I mean, this is a little different because this is, well, it's not. I mean, we talk about ordinances, we talk about contracts and agreements. I mean, they can be modified as we go forward. And it's at some point kind of like that. Let's put the wheels on this thing and get it rolling, and then we can tinker with it as we go.
And in particular, once the board of the multi-jurisdictional housing authority is formed, that creates a table for all of the contributing partners for the multi-jurisdictional housing authority to sit together and get into the weeds about how exactly what are the priorities around affordable housing? What are the resident services that the multi-jurisdictional housing authority should endeavor to provide in the first year? Exactly how might we consider pursuing revenue streams for that organization and really get into the strategic priorities for that organization with a group, with that board being a representative body that includes all of the contributing partners.
I think it makes a lot of sense for us, since I'm hearing a lot of support and no comment, to formally approve this agreement.
You good with moving forward, Randy?
Yep.
All right, I'd like to move that we approve the intergovernmental agreement to form the Clear Creek Regional Housing Authority.
Second.
We do a friendly amendment just to make sure that the version that is in front of you is conformed to include the signature pages of the other municipalities that have participated and approved it.
I see a nod from Mitch.
Yeah,
Nod from
I nodded.
Randy.
That was, you were looking at it
Interpreted
while
that
I
as
nodded. So, yeah.
being included in the motion.
Thank you.
Motion a second, all in favor?
Aye.
Aye.
Aye. Yay.
Yay.
We're up to four. We're up to four. We've got one more. And I think the next thing that we want to talk about is what to do with the Clear Creek Housing Authority. Can you,
Yeah, I mean, I think from staff's perspective, the recommendation is we either disband or move to figure out how to transfer the functions of that organization to the multi-jurisdictional housing authority. I think the most important thing, regardless of exactly what we do structurally, the most important thing to understand is that the Clear Creek County Housing Authority cannot be a functioning housing authority really in any way. That the one thing that it does right now is the two things that it does right now are it provides it houses the ownership, a small ownership for Riverbend that provides the LIHTC authority, if that's the right language. And it also provides some funding for the Section 8 housing work that we do through Grand County. I think what we want to do is try to keep things kind of clean and focus the work going forward on the multi-jurisdictional housing authority. We would want to keep the boundaries around our existing functioning of the Clear Creek County Housing Authority to that work, and then move to figure out what we want to do exactly with those two things that are currently under the umbrella of the Clear Creek County Housing Authority.
I think the first thing that pops into my head, two priorities then are once the ink is dry on our agreement, the IGA, and once we exist then as a formal entity, is to need immediately then one of the first tasks in front of the housing authority should be, at least it would be our recommendation as one member of the housing authority, to figure out what to do with that LIHTC equity, all that kind of stuff and obligations, number one. And then secondly, whatever we do around all Section 8 stuff, the services that we provide, that there is absolutely no lapse in service and that people get what they need. And we don't say, okay, now it's your problem and toss the ball and then have people sitting around waiting until somebody gets their act together. I think we have kind of a moral obligation to keep that stuff, to fill those responsibilities until we can pass the baton on the run with the other side running. And so there's no lapse of help for the people that deserve it.
Yes.
Does the Clear Creek Housing Authority have any additional assets?
I don't believe it does.
Just have just the involvement with Riverbend, the slight involvement, and that's it.
Yeah.
and Section 8?
But that's not an asset. That's a
Right.
task.
Yeah, good call.
Right.
Currently, the proposed budget includes that funding for Section 8 in the housing fund.
Correct. So what makes sense to me is, and this isn't a super strong opinion, but it makes sense to me that as a short-term goal, as it like I would love for the 2025 budget to not have the Clear Creek Housing Authority in it. I would like for this board to direct staff to pursue the dissolution of the Clear Creek County Housing Authority in 2025. That would mean transferring that asset to the multi-jurisdictional housing authority. And that would mean transferring the contract for Section 8 vouchers to the multi-jurisdictional housing authority. And we can have a conversation about whether that involves the county, is it $10,000? The $10,000 being added to the multi-jurisdictional housing authority. I'm not trying to like immediately burden it with this expense.
So if you're,
What I am trying to do is just clean this up so that there's one organization.
Agreed, as long as that's a reasonable timeline to accomplish all of that legally so that, stuff happens when it's supposed to in timely fashion, all the services that are provided. That's the main thing, is that there's not, because that's an ongoing thing. We can't have a lapse in those services. So that I applaud that ambition as long as we don't take an action that then causes us to derail the other thing for any amount of time at all.
So I just want to clarify then. So you're saying 25 budget would not fund housing authority, so we could, is that what you're saying?
No, I misspoke. What I mean is the budget we passed, the 2026 budget. That's what I mean.
Oh,
That's what. I mean.
oh,
That's another story.
oh.
Yeah.
I was gonna say,
That's-
we got 30 minutes, okay, to get that done.
My lunch, that's good.
I misspoke. I understand the horror that I saw on your faces.
Well, I mean, I think, I'm looking at Rachel, I think we could just move that $10,000 from the housing fund to a line in the general fund, so it's not, so then the only thing we have left to do is dissolve whatever legal actions need to happen to dissolve the actual housing authority itself.
I'm not asking for any changes to the 2025 budget based on this.
Okay,
I'm asking for us to direct staff to pursue the dissolution of this organization in 2025.
Okay.
That should be easy.
I think it should be before the new organization is up and running, so it's clear that one's dead and there's a new one.
Yeah. Again, same line I give, as long as that doesn't cause any lapse of service and action that we're currently responsible for.
I mean, I think right now staff, at least for my part, cannot fully I do not have a clear vision on exactly what the dissolution process would be like, how to resolve the ownership and of the equity of the Riverbend process and how to transfer that, what all of that would look like. So it might not be a linear process. There might need to be some overlap of that transition, whether we're dissolving one or merging them or, exactly what the structural change would be. But I definitely believe that in 2025 and not very far into 2025, we can get this figured out and have this transition accomplished.
Yeah,
Thanks for making good decisions for us.
Yeah, so that sounds settled.
I think so, yeah. I'm just imagining it'll take a second for the new multi-jurisdictional housing authority to figure out where the keys to the bathroom are or find a bathroom somewhere, and first, and then have somebody that actually operates in that office and then does those tasks. And so, again, it'd be good to hand the baton off once that person's there and running and you just hand it over to them, so.
Yes.
Thank you.
So then the next thing is to discuss, I think we're an appointment in the formal sense isn't what we would want to do today, right? We're not set up to do that, although I guess we're posted.
more of a process question for this. Is this an appointment this board's making? Is this an appointment we're gonna do next January and the brand new board?
I think in early January, the board, whatever we do today, the new board is going to have the opportunity to reconsider this. I'm holding up the appointments document. I don't think that's a reason not for us to discuss who we want to be appointed.
Well, some of these, yeah. I mean, I'm willing to talk about anything. Some of these are probably, I know the new commissioners coming in are going to have some thoughts. They've expressed some thoughts to me already about where they'd like to work on things. And I'm guessing that's something that will have to be resolved among the parties going forward. That said, I'm happy to dispense any wisdom that I can to that decision that will be made by somebody else.
I don't believe there's an MJHA appointment on that list at this point.
But that's a new one, sure.
What makes sense to me over the next 2 months at least, and what's likely to make sense to me next year is that we appoint Amy. Amy has now, after the loss of Jonathan Kane from Idaho Springs, the person that has all the knowledge
On the
about
housing thing, you mean?
about the housing authority. Yeah, and that's all we're talking about. And so that's my sense, is that we just for now sort of agree that Amy is going to be our point person on this, as she has been. And I don't know that we need to do anything more formal than that until January, but if we do, we can.
Okay.
Does that, but let's, it's just like my opinion.
I support that thought and it seems like the staff likes it too.
Randy?
Yeah, I'm completely in agreement with that.
Awesome. Then
And
I
I
think,
was listening, I was paying attention. I made that decision about about 1/3 of the way into what you were saying. So I just was off to something else in my head.
um, then I think we're good. Thank you all. Thank you, Amy. This is awesome. I'm not gonna make a speech about it.
To talk about more things on this today.
Thank you.
No, we're not on the agenda to discuss this.
That's what I thought. Okay. So we maybe pick that up the next meeting if we have a party thoughts on some of this stuff that could be helpful to you guys as you make your decisions in the future.
I wasn't anticipating we would review this document as a board this year. Can you share your intent in having printed it and
We
delivered it?
just handed that out so you understand that there's a bunch of spots on there that need to be changed. It's typically something that gets approved in January in the past.
Let me word this differently. If anyone has any interest in what I think about some of the things I've been doing for 6 to 8 years here and how you might think about doing that going forward, I'd be happy to share those in any setting that's helpful. Just institutional thought going forward, not presuming to have any authority at all over what decisions are made going forward, nor wanting any. Okay, just good enough. I'm just throwing that out. And I don't know what the right setting is to have that discussion. But normally needs to be in a public meeting. So that's the only thing. And I'm not suggesting it today. I'm throwing it out there. It's an offer to do that. And if you don't want to talk about it this year, then, I mean, we can talk about whether we should talk about it this year. I guess this year is this year. But I'm just throwing that out as just an idea about how to approach some of these.
If you want a work session on it, I can accommodate that. I certainly plan on hearing your thoughts.
Yeah, and I'm thinking what's a legal setting in which to hear them. That's why it seems like some kind of discussion or work session would be in order.
I don't know what was handed out, so I can.
What's that?
It's
The appointment list.
the appointment list.
Yeah, anyway, and somebody's going to make their own decision about it later on anyway. I just want to throw that stuff in the mix. So.
Next thing on the agenda is consideration of resolution 24-79, a resolution supporting the formation of a regional resilience team to support, advise, and lead economic development initiative in Clear Creek and Gilpin counties. Brian, you're listed on the agenda. We also have Lindsay Valdez, the director of the Clear Creek Economic Development Corporation. Who should I give the floor to?
I'll take it first.
Okay.
Thank you. Lindsay's here representing the Clear Creek Economic Development Corporation, and you're considering a resolution to support the formation of a regional resilience team. All three of you attended a resilience mixer that the CCEDC held earlier this year. That was followed up by the next morning with a breakfast with the county represented, all of our municipalities. Gilpin County represented their municipalities, kind of coming together to focus this and force a conversation about economic development in both of our counties. That resulted in quite a lengthy document that you guys prepared, the regional resilience framework. And one of the recommendations that is to form this regional resilience team. Lindsay has attended 2 of the last 3 mayors and commissioners meetings, briefing everyone on the resolution itself and the framework. And we're here today to have you consider adopting the resolution and appointing someone to serve on this resilience team. So I'll stop there and turn it over to Lindsay and let her fill in the blanks.
Yeah, no, that was great. Thanks for having me this morning. As you know, we've been working on this for quite some time. We met earlier in the year, as Brian mentioned, to discuss economic development. And just to put this on your radar, we are planning on having that event that we held in February will be an annual event. So we're looking at tentatively the 13th and 14th for the follow-up event, where we hope to introduce this resilience team. We all know that economic development is extremely important in our county, given the challenges that we're facing. And so we'd like to continue to have those important conversations of how we move the needle and can move things forward. The CCDC is planning on being the convener of this. We recognize that we're not the subject experts in housing or broadband or childcare, but we have some really great groups such as the MJHA and the broadband group, and we have a childcare group as well. They are the subject experts. We would like to have someone appointed from each of these areas to be a part of this team. One thing I should note is, so we, as the administrator of the CDBG revolving loan fund on behalf of the state, we're Region 3, so that covers Clear Creek and Gilpin counties. So we have made this a regional effort. So Gilpin County is included as well as the municipalities. So we're asking for the adoption of this resolution from Gilpin as well. We're also on the calendar to go before each of Clear Creek's municipalities to adopt this resolution. So we really had that buy-in. I'll open it up for any questions you might have. I think everyone's familiar with the document that we put out, this rural resilience document or framework. This is intended to be a living document. It's about 90 pages long. It will change as we do this work, but it summarizes the community feedback, leadership feedback, as well as consultant feedback and studies that we've done related to economic development over the last decade. And that'll be our starting point for kicking this group off.
Thank you. Questions?
Not right off. I don't have any questions.
Comments?
Lindsay, I acknowledge that your organization is going to be the convener for this work. I think it's important work. I like that there's an action plan to move forward. But I'm going to reiterate my concern that without somebody, an individual responsible for making it go forward, I'm concerned that it's either going to be delayed or it won't be completed. I'm looking forward to seeing it go, though.
Yeah, we definitely, as a small county community, have capacity issues all around. And so, this is as we go, I think if we start to recognize like, okay, we really need some additional effort or assistance here, we can start looking at that and addressing it, have those conversations with Clear Creek and Gilpin. One thing I should also mention as far as the appointment, we're encouraging the appointment of someone who's either a policymaker or is advising our policymakers. So just keeping that in mind as far as the person that will be appointed to this team.
You mean from any entity who sends someone to the team, you would like that person to be a policymaker?
Well, so either a commissioner or someone from the county that is directly creating the policies or presenting policies to be approved, really want to make this an action-oriented group. And so the more conversations high-level conversations we can have with our policymakers and leaders, the better.
Right. I think that makes for more efficient progress because there's not an iteration where you're constantly going back before boards and having to explain to them and then losing stuff in translation through those communications. If you've got somebody in the room that's got a better feel for the pulse of what this organization is likely to have as their input, then you don't waste time going back and forth until you find a solution.
Yeah.
It's the same model that we honestly tried to use at places like the CE, NOCO, I-70 stuff, where there's multiple organizations coming together and you're trying to find agreements and you keep talking about what an agreement might look like, but then that's why they prefer to have somebody that's either at a policy level or a really upper level management directly connected and has a good feel for it in the room. So they're not wasting time.
And I will also note that we're really at a tipping point. There's a lot of synergy happening right now at the state level as well, where we just finished comprehensive economic development strategies, so the SEDS document for our region. And that was a partnership. Dr. Cog was the convener of that, and we were all at the table. Denver Metro EDC was a big part of that as well. And so the document that the CCDC, our organization, put together is very much kind of in response to that SEDS document. It's meant to complement that SEDS document. The way the leadership resilience team is set up is similar to how we worked on that SEDS as well. So we're hoping that a lot of ways that we can continue to partner and become more of an active member with Denver Metro EDC. Not currently a member, but we are part of their territory. We're very active with Dr. Cog, and they love working with us. So we're excited to continue those partnerships.
I definitely support Clear Creek County's engagement in this partnership. It's important for us to acknowledge as an organization that we're one of 5 that really can't point to any real investment in this area. And that's something that we should seek to fix in order for the comments I'm about to make to be practical, right? My take on the rural resilience, what are we calling this? Framework.
Yes.
Is it lists things as strategic actions, and it communicates them as though there was a robust strategic process to inform them. I was there for that breakfast, and I know that I would define breakfast as a brainstorm, not a strategic process. I don't mean to criticize. I don't mean to criticize your efforts in pulling this together. You have taken the results of a bunch of different studies and comments, and basically everything that's on the wall, we're going to make it actually stick, and we're going to put it in one place. But I'm going to provide an example here. Consider keeping Guanilla Pass open year round is listed as an immediate strategic action. I don't view that as a strategic action. I view pursuing enhancing winter recreation opportunities on Guanilla Pass as a strategic action that I would support taking immediately. So that's just like one example of where I think this document needs to go for us to really be able to call it the result of a strategic process rather than a brainstorm. I would encourage this document in its next iteration to frame more carefully the state of this, because I think it's important for us to acknowledge where we are and where we need to go. And where we need to go is to figure out how to take all of this stuff on the wall and figure out what actually is strategic. So that's like, that comment aside, I'm really grateful for all of your work. Definitely support moving forward with the framework. Not with the framework, with the resilience team.
And I really appreciate the conversations that we've had around that. And you're 100% right. So that exercise that we did really was a community brainstorm session. I will say the recommendations from the different studies had a strategic process behind them, and a lot of public input. So those I've left alone, but we do have a kind of revised version of this document where instead of saying community stakeholder strategic actions, it's more of a suggested or community brainstorm. The idea behind this, again, and one of the first actions that this team will take is reviewing all of these items and saying, okay, what truly is, what, not to start it off on a negative, but what really isn't feasible, and pulling those out, but keeping them in the document in another section that's developed that says this isn't feasible and this is why. So Guanilla Pass staying open year round, well, as residents, we may want that as a luxury. That would be great. Cost wise, it just doesn't work. And we explain that. And so that way it's keeping that transparency. So, because I've taken that as the example, heard that said over and over, well, why can't we do this? Why can't we do this? So as long as we're communicating that, and then we can move on to that low hanging fruit that really does make sense financially and that we can move forward. So 100% agree with you that this isn't intended to be the document that says this is exactly what we need to do. This is everything that's been suggested, said over the years, whether it's consultants, experts in the field, or community stakeholders. And we kind of do that review and determine what's next. So that will be one of the first steps of the resilience team.
I think it's important. I think the brainstorming thing is really valuable and has been. So there's nothing wrong with that. I think sometimes when we're in a hurry to get things done or we're coming at it with low bandwidth, we take a brainstorm session and then we write a report about it and call it a strategic plan or a master plan or something like that when it's really a first step. You know, it's okay. It's actually okay to have a brainstorm session before you write a strategic plan. Because what happens is you bring a lot of community members together, you splatter paint at the wall, and then you back up and look at it like a, you know, an ink blot test. And then you say, okay, we need to build a plan to encompass these ideas, to be able to filter them according to their appropriateness
Yeah.
and think about other high level things. So you you don't let that guide all of your high level thinking, but you realize that the structure of your initial plan, the framework of how you're going to create a plan needs to have a home to consider these kinds. So these are the kinds of things that's what came out of the people that came in the room brainstorming. Great.
Yeah.
But then enter that high level strategic plan phase that encompasses that and everything else you can think of at a high level policymaker level, and then move on from there. So I think what's happened to date is simply as far as you've gotten so far. It's not a plan in and of itself.
Exactly.
That's just speaking to what George said a little bit ago. We need to wrap our heads around which of these things make any sense at all and which don't. And how can we then focus on and we can prioritize those large pieces of the plan and what needs to be figured out first and then executed second.
Yeah, and maybe we reword, not to go into the weeds, but maybe we reword what this document is actually called. As I mentioned before, the CCDC doesn't want to control the document and say, this is, you know, how it's going to be. So we really want to, and where we're starting with this resolution, get the team together, and then that team kind of, that's a point that will be made when we have our first meeting and start to kind of dive into this work and things may be reformatted, and that's totally fine. This is a starting point just to get the conversations going and the ideas out there. Like you said, we've kind of put it all out on the wall, and now we get to step back and look at it and see what makes sense for us.
Yeah. And I like the reason somebody's going to read this document in 10 years and wonder if we're able to execute. And if they look at this document in 10 years and they say, you didn't ever consider keeping Guanilla Pass open year round. It's, you know, like the framing in this document doesn't set expectations correctly.
Yeah, and we can rework that. And like I said, I think it's important to pull those suggestions out, but keep them within the document in a different section and say, at this time, this is why it's not feasible. That way, you know, we're answering the questions. So when it comes up again, we can easily address it.
Yeah, at least
The document.
yeah, have the conversation, but you know,
Yeah.
I mean, we used to keep Guanilla Pass open year round and a long time ago. And then we figured out we couldn't afford to do it.
Very expensive.
And it cost a lot of money and so we haven't done that since. And those reasons are still valid and things might change, but it's not like we've come up with more revenues to do it since then. We used to also keep the road open for 2-wheel drive pickups to build more lake in the summertime, just because, you know, county commissioners like to fish there and stuff like that. So they're just things we don't have discretionary revenues to do that kind of stuff with.
I think it was something around how you have to handle dynamite after 9/11 that greatly increased the costs.
Mm.
Any other comments? Welcome a motion.
All right. I move that we approve resolution 24-79, resolution supporting the formation of a regional resilience team to support, advise, and lead economic development initiatives in Clear Creek and Gilpin counties.
Second.
Motion and a second, all in favor?
Aye.
Aye.
Aye. Motion passes.
So
Next thing we want to discuss is direction about the appointment, right?
Sure. Yeah.
And we will have our first meeting. We're expecting to have it no later than January, and then we'll introduce the team mid-February at the annual event, which we bring the community out to.
Staff, what are your thoughts on?
Who would be the appointment to this?
Yeah.
I think based on the requests, it's one of the commissioners. Or I guess I would ask you to appoint me.
It would be probably one of the commissioners or someone at a, I'm thinking economic development level. It would be the, most likely one of the one of the commissioners, ongoing commissioners. Or you.
Yeah. I mean, as your appointed rep to the Lindsay's EDC board, there's some tie there in terms of what I'm doing with the EDC board too, so. It's just whether or not one of the new commissioners, or I guess, or George has a interest in wanting to be that representative.
I mean, the most compelling thing I can think of is that got you appointed to the EDC.
Yeah.
We should have you do this too. And if
That
we-
makes sense so that the two aren't siloed from each other at all. Not that, I mean, just accidentally siloed, just by virtue of bandwidth.
And I just a quick technicality, we haven't appointed you. We asked you to go apply because we don't have any appointment authority over this organization anymore.
That's a good point, actually.
So let me think that through. So the way our CCDC bylaws are for our board of directors, in the past, we've had appointments from each municipality. The board at one point was up to, I think, 14 members, and we were having a hard time with quorum and whatnot. And so the board ultimately decided to take it down to no less than 6, no more than 9. Excuse me, 7 and 9. So with that said, we don't have appointments to our board of directors. However, of course, we include our leaders and representatives in that mix. Where am I going with this? With this group, I don't know that, I mean, we're asking you to appoint someone. I mean, that's basically the resolution is saying, we hope you support this and please appoint somebody to it. So it's not part of our bylaw structure.
It makes more sense to have us, in my opinion, to have us appoint to this, because otherwise you're asking a group that doesn't exist until it's there.
Yeah.
I mean, how do you get the chicken and the egg, cart and the horse? What do you do for, I mean, you need somebody to, and the second thing, even if they did already exist, you'd be asking them to select who they want from your organization. Otherwise, I mean, that's really where it's at. So in the end, they have to be at least proposed by us and see if anybody says that's, and that way, I mean, I would think the only place that other board would come back or the director or whomever would come back and say anything would be to say, we're looking for somebody that's closer to a decision-making role, to a policy-making role or something like that. Just that's about the only thing I could imagine them objecting to, is that we hadn't picked somebody that was close enough to the heartbeat of decision-making.
Yeah, we will not object to the county appointment. I mean, we're going to leave it up to each entity. I'll be reaching out, for example, to the broadband group and ask them to pick someone to represent broadband. Same with housing. The MJHA, the director will likely be that person. But again, it's not for us to decide. We're truly going to be the convener. But it will be up to each organization to appoint the person, and we won't object to whoever is appointed.
Of course. And I wasn't trying to imply that. I probably shouldn't have brought that up. I'm good with where we're at. My only other comment on this is that I think these local governments, these 5 local governments, Clear Creek County included, need to find the capacity to invest in more activity in this arena. And one of the most obvious vehicles is by investing in the CCEDC. Clear Creek County used to provide a portion of sales tax revenue. I don't believe that sales tax revenue was used well at the time. And I know right now there's not an opportunity for us to make that investment with our budget. But it's a conversation that I think, like when I think about the strategic conversations, the first conversation is, are we going to decide as a group of 5 governments that we want somebody to have capacity? That's my final comment. So anything else?
I think we approved it and voted on it, right?
Yep, and we
Okay.
I think settled. I think we're agreed that we're gonna ask
Yep.
Brian, we're gonna appoint Brian. And I think that's it.
Thank you, Lindsay.
Thank you.
I'll send you a copy of the resolution. Okay.
11:38. I think we should jump into executive session.
Rather than take that next grant thing.
I know that the sheriff is trying to be done by around noon.
Oh, I thought you said you wanted to do it by noon. I
I thought it would start
absolutely.
by noon,
Yeah, let's go with it then.
but
Do we-
it's still before noon.
He said he's prepared around noon or before.
Well, do we want to take up item 6 instead?
Yeah, I think you can do that and then we'll call him over. You should be fine.
Yeah, we can knock it out quick. It's just one more thing off the list, so.
Okay. Consideration of approval of National Seaway Scenic Byway Program Grant. Brian, you are listed as a person, so I will start by giving you, Randy, I know that you have been working on this and you're
Yeah.
you're
It's
gonna.
not my name on it because I threw it on there, but I know that Randy's been working on this. It's a grant that he wanted to apply for. It's due December 6th, I believe.
Right, and that we were going to consider this on December the 10th. And then it turns out because actually the application itself, the application doesn't go into the federal government until around the 16th. But CDOT wants it in time to be able to go through and do some, cleanup, editing work on it, make sure it's all compliant with the request with the NOFO. And Lisa can speak to that a little bit too. And they had we'd received one piece of news in a meeting recently in which they told us that the 12th was when we had until, and CDOT came back and said, well, really the 6th is when we'd like to see it. So we've got more time in office to look at it. Am I correct, Lisa, on that? Yeah, that's what I saw from Lenore and from Anna, I think.
Lisa, my apologies. I should have invited you up here. Will you join us?
Yes, please.
Sorry, I didn't mean to interrupt you.
That's okay. And what I'll say about it is I think it's a grant that it's something we really want to get done. CDOT wants to get it done. The National Forest Service wants to get it done. A lot of people want to get it done. There are some catches in that it requires that there is a subrecipient of the grant and fiscal manager, and they should, for logical reasons, be one and the same. And then there's project management that takes place. As usual, there's multiple layers of project management. There's an oversight organization, and then there's a person, a project manager of a project is a person really writing the contract, scheduling the meetings, doing all the stuff and holding it. And that's not, I think, what CDOT is proposing to do with their project manager. They're proposing to have someone who oversees the project manager and just receives the reports at CDOT to go their portion of the grant management that is prepared for them. And so it seems like, and this is something Brian had brought up to me in a previous, and we both agreed on it. I can't remember which one of us brought it up first, but if we're the fiscal manager and the subrecipient and fiscal manager, we'd like to know that project management is housed with us so that we can control our destiny and to know that we're under no financial risk in managing the loan, to make sure that it's managed properly and happens within the budget that's proposed and all of that. There's all of those levels of subrecipient and fiscal manager have some level of internal bandwidth that's consumed just to do the reporting. The project management itself is probably done best contracted by whoever the subrecipient is to someone who would manage the process, unless they had a spare person in-house that they could devote to this, like a quarter to a third of an FTE or something like that over 3 years or so. And that's something that I felt that Clear Creek County probably would not want to do. And others have not, we don't have, some of them have technical reasons why they don't want to be the subrecipient. And so before, when we applied 2 years ago, we decided that we could do that and it would happen within the bandwidth of myself, because I was sitting here 2 years ago. Most of it would have happened while I was here and I would have just done it not pro bono, but as part of my job as county commissioner and tried to handle that aspect of it. I'm going to be gone and out of the picture. So it would be contracted to someone, and the presumption is that they would be able to get it done. That part of that project manager's scope, I would recommend, would be that they take care of all of the, I'll call it the underwriting work of the quarterly grant reports and stuff like that that go in, and that they would create, they would do work on the fiscal side to the extent that they can recommend to the finance department, because if we're the ones writing the checks and taking in the grant funds, we would try to reduce the workload on our staff. So this person would be contracted to handle, roughing in the grant reports and getting it ready so that they can then be submitted by the county, and creating a cogent financial report and package for disbursements each month that would go into the warrant register and stuff like that. So that it wouldn't burden county staff too much. I don't know that we have a real clear picture of that right now, because we would want a pretty good guarantee that we're not burdening bandwidth to the county moving forward. And so I'm enthusiastic for the project, but I'm trying to be really realistic in this description, that I want everybody to understand that I think it's really important that we make sure we're guaranteed that we don't burden staff too much and that we don't have financial risk. And so it's important that whatever we represent on this grant application is, make some of those pieces clear so that they relieve us of financial risk and I'll call it an HR burden on our staff. And I think those things can be done, but I think we've got a little bit of tying stuff together to accomplish this. Lisa might know the answer to this one. If I knew that the grant application could go in with the question unanswered as to who the fiscal manager is on the grant application, let me ask this question. Do you know if the subrecipient and the fiscal manager once the application goes in, are they named, and is that unchangeable? Or is that something that can be altered once the application has been, can that be left as a to be determined on the grant application itself that goes into FHWA?
I don't know.
Well, I think that's a question we need answered. And so if we make a decision today, I think it should be a conditional. My recommendation is it's a conditional decision we make today, conditioned upon either our ability to have gotten the concurrence from the other partners, especially the National Forest Service and CDOT, that we can choose a project manager that can be under our oversight as well, to make sure that this thing's being handled properly, that the whole project is run properly throughout. And secondly, to know that we're not legally bound to be fiscal manager if this grant is awarded. And when the grant's awarded, they don't like it, but you can always decide not to accept the grant too if you've come to that conclusion. I'd like for us to try to keep this thing alive moving forward and be the applicant right now. But I think our decision should be conditional upon making sure that we have the ability, we've got an exit door to this thing if the answers don't come back to our satisfaction on a couple of those questions.
Mr. Chair, I guess that you're right. We need to get an answer to that. I guess I'd be a little surprised if they would support a grant that has a different fiscal agent from who's actually submitting the grant itself, but we need to get confirmation on that. As
2 years ago, we were allowed, we could submit the grant and someone else could be the subrecipient and fiscal agent, but it's still a question that has to be answered about who it's going to be.
I mean, as the board knows,
Sorry,
go ahead. As the board knows, we're bringing you a budget on December 10th, and we're asking you to make some difficult decisions, and I have concerns about resources. Our ability to manage the grant, to manage the project manager, et cetera, as Randy has already indicated, right? So that's my main concern, is how we're accepting a large amount of money in a pretty late, I'm not even sure exactly what that number is yet, any very lengthy grant. And I think we need to hear from the board where this falls on the priority list, considering resources are going to be tight for both financially as well as time, right? The time and the ability to manage something like this. So but if it's a priority of the board, then it becomes a priority of staff. So that's what we need to hear.
I think one other piece that we're penciled in at right now, after discussions we've had previously, Brian and I had, we're penciled in at about I think a $20,000 match on this thing right now, is my recollection, that our grant match would be around $20,000. Now, since money's money, it's fungible any way you go. I mean, that could either be delivered in terms of cash, or I believe it could be delivered in terms of an in-kind contribution, which could be some of the, finance department, fiscal management, and, disbursements and receiving funds and stuff like that, because built into the grant is what we have built into the budget right now is that Clear Creek County would be reimbursed for the cost of any of those activities that we undertook. However, that's on the one side. On the other side, though, on the disbursement side, we would be, like the other partners in the grant, responsible for a $20,000 either cash match or in-kind match or something over the 3-year period as the grant went forward. It doesn't have to be paid immediately. So it's a few $1,000s a year for about 3 years. Anyway, so that's a more complete picture.
So who would be crafting the application?
Right now, it's Megan Musto from the National Forest Foundation and myself, and with Lisa digging into, and then on the CDOT side, it's overseen by Anna, I can't remember her name, and by Lenore Bates, who handles their National Scenic Byway program for CDOT. And they receive the grant, but they're looking our grant over to make sure it's compliant and helping us with it. And I wrote the grant 2 years ago with some help from Beth, and I think that was it. Beth and myself.
Looks like some of this funding for this grant is from IIJA, which means we could use the DOLA Loma funding to pay for the match and maybe get grant writing assistance from Alyssa at the governor's office.
So we could pick up our grant match, and have that paid for.
Yeah.
Give you a pass a grant match from the state.
Yeah,
That's interesting.
just an idea. I'm not trying to, sorry. I'll be quiet, I know.
Thanks.
I mean, it's hard for me to imagine a context where we apply for a grant and receive the grant and don't see in the grant agreement that we're responsible for the execution of the program. And this was kind of, Peter, I wanted to ask you if you share that perspective or if you have anything that you want to add.
Concerning whether or not we have the capacity.
No,
Whether we should be responsible for executing the project if we're responsible for the grant.
the kinds of
Financial.
obligations we're probably taking on in choosing to apply for a grant.
I think we absolutely are accepting the obligations. If we are the grant applicant, we are in charge of the grant. We are in charge of the processing of the funds and making sure that it is adequately monitored.
And and that's my assertion as well. That's what I was trying to make.
And so whoever we contract with to actually manage the program, et cetera, that oversight is ultimately on us.
Right. CDOT will supply an oversight project manager, but I think that we have to own the project manager on the ground. And we need a commitment from them that we get to make that's got to be a distinction. They're under our control. And if they don't agree with that, then I don't think this is my baby. I want this thing to happen, but I don't want it to happen at any risk to the county. And I would suggest that we not volunteer to be, subrecipients and fiscal managers if we don't get that commitment that we have control over that project manager.
And my comment about resource concerns is that, right? It's overseeing that, the work that we need to do to ensure that the work happens.
Right.
I have struggled with this one because this is important work. And the challenges that this organization faces, the decisions that we're going to be forced to make regarding our budget moving forward, I just don't see how we can try to take on a multi-year project like this right now. I just don't. I just can't see how that is wise given the broader context of the challenges we face. And so I don't know how to move forward with this and keep a straight face with staff in the community that we're doing everything we can to be really strategic about the use of our very limited resources.
Yeah, I break down a little bit on that logic at the end, and it's because we have a lot of other things that we are deciding are important enough to us to do that we're still going to try to do, and they're good for the county. And I think this one is too, in a lot of ways. So taking it on is kind of like taking on the other ones. I believe we can take it on. I just think we have to take it on in a responsible manner that mitigates risk. And I'll just describe one last time that, once again, I believe that this should be done by contracting a project manager that handles virtually all the load except the signing the final report, that they would even help create as part of their scope of work, that contracted project manager, which would be paid for completely out of the grant and the matching funds from everyone, that person would handle 90% of the load, 95% of the load, so that at the end, what happens is our finance manager reviews, or whoever is assigned to do this, reviews the quarterly application that goes in and says, yeah, the numbers check out. It looks like it's filled out properly, and signs the thing, and takes a small amount of their time. And part of that project manager's role is also to create, periodic reports, monthly reports to to whomever is assigned to oversee this. It could be Brian or whomever, to see that report coming in and see that here's how the project is progressing. Here's how things are going. So it's really like overseeing that person. Somebody has to take a report from the project manager of this project, that would be farmed out to someone who is overseen by a finance department on a quarterly basis or on a monthly basis before checks go out. And money is received, and that the project manager's oversight of the project is just overseeing that there's a window into it on our side. And it's going to take some hours. I don't think it would be a lot of hours on a monthly basis. I think it would be only a few on a monthly basis at most. So it's just a value proposition of whether having the work done and seeing it happen here is worth those hours. And I don't think we should do it unless we can get commitments that we can have a structure in which it doesn't burden us with a bunch of hours, so that it's not a drain on us, and so that that we know the job's being done well by hiring somebody competent to do it who's under our control again. And with that, I think I've already said that once, so I've said it twice in this meeting, so it's good enough.
So the grant's written for the most part.
It's getting there, yeah. It'll be finished by the 6th. We were setting up a meeting that I didn't ask for, and this is one of the things I want to talk to National Forest Foundation. And if we do decide to stay in this game, then I want to go back to them ready to play the poker, if you will, and just let them know that here's what we must have if you want us to continue and want us to be the party that's submitting this grant. We must have all these commitments, or we're not interested in going forward. And one of the things that, I'll just be honest, raised a red flag for me the other day was when Megan sent an email requesting us to put a meeting together of Brian, Lisa, and myself with her to schedule out the rest of the writing of the grant to get it completed. And it made me question how much the National Forest Foundation acting on behalf of the U.S. Forest Service, who has already put $108,000 in matching funds into this and parked it at the National Forest Foundation. U.S. Forest Service provided it and parked it in an account at the National Forest Foundation to be used for this grant. So they're very committed into this work and getting the grant done. But when somebody from the National Forest Foundation is calling our staff to set up meetings, there's a good and a bad side. We're moving forward. Let's get the grant written. There was another question about, okay, who's in charge of this thing? Who perceives himself to be in charge of it? And right now, I think it's the National Forest Foundation. And then we need to get some commitments about not burdening our staff time. Number one.
If they're in charge, shouldn't they be the ones submitting the grant?
Well, see, but they're not the actual land manager. That's the U.S. Forest Service. They're like the agent of the of the U.S. Forest Service in this case. So they're not that's like asking asking our attorney to take the legal liability. He's not the right person to do that. And the Forest Service has, I don't think as a federal agency, they can be the subrecipient. It's a technical difficulty there, but they're also the largest contributor. And this time around, they're really into the grant. They want to make it happen too. Their intentions are good. They're doing what the Forest Service does, which is taking a pretty leadery role in the conversation right now. Do you have a different opinion?
No.
You concur with what I'm saying? Did it bother you a little bit when you got that request for the meeting from her, as though she were in charge of our staff, kind of?
Mm-hmm.
Same with me. I need to have a discussion with her about it. And we need some ironclad commitments to go forward, I think.
I don't have enough information to make a decision. What's the impact of doing nothing today and me spending some time with Randy learning more?
We don't have another meeting, and if we don't have an approval to submit the grant application to CDOT, well, in good faith, when we submit something to CDOT, or when we move forward when we say we're either in the game or we're out of the game, we could hedge our bets and have the ability to withdraw before the grant application goes in. That's not acting in good faith with our partners who are all working on making the grant happen too. We need to be straightforward with them. So the difficulty of not making a conditional decision today is that I can't look at them with a straight face and say, yeah, we're in. Let's move on with the grant application without our having these couple of problems ironed out. Who's in charge? And are we going to have oversight of the grant application? And are we going to make sure that you filter through one person in our county before setting up meetings for all of us and burdening their time already when we haven't even started the project and you're trying to burden our staff time?
If you want more time, I think the thing that we would need to do is schedule a special meeting to discuss this again next week.
Can be short.
My
Yeah,
opinion.
it could be short and it could be in a couple of days.
Yeah, I mean, so I can accommodate that. I'll share my opinion right now. Is the best way to give this project a chance to happen is to send a clear signal today. And the preference that I have is to send a signal that we are sorry, we are too resource constrained to be the grant applicant.
Period. We're out of the game.
That's my opinion. I would rather see us, we asked staff to complete a facilities assessment in 2024. That's not going to happen. It's going to be on their work plan in 2025. That's just one of a bunch of examples. And this is important work. It needs to happen. It doesn't have to be our responsibility. And I don't think it's something that we can ask our staff team to take on in the context of the kinds of decisions that we're forced to make with a $4 million budget deficit.
I kind of saw it as our opportunity, so we have a different philosophy about the subject matter.
Oh, I would, if in a context where we have a sustainable budget, I completely agree.
I have less fear about the financial and staff impacts if we manage it properly up front and how we set it up, which is what I'm asking for. As far as things that are and aren't our responsibility, I don't even think of it as our responsibility as much as our opportunity to make a statement, a change about, who we are, where we are, about the place and the people that are here and how we perceive history. And if that's not a big enough goal to consider it an opportunity, then that's fine. I just would like whatever decision we make here today to be reflective of that thought. You know, acknowledgement of that thought, that it's a choice.
I get it is a choice, and that's a choice I would make. So Mitch, what's your preference here? You want to schedule another meeting? Or do you want to have an opinion today?
I want some time to learn more, and the meeting can be very quick and it can be within days.
I would say this in the interest of keeping things simple, so we don't burden staff and ourselves with more meetings about this too. If the answer is that even if we are fully funded, and even if we have oversight of project management, and even if we make the decision that we will outsource that project management that will be fully funded, this is not something we want to spend our time talking about and thinking about for the next 3 years, then we can make that decision today. Because my proposition was that, my proposal was that we dot those i's and cross those t's to mitigate burden and risk. And then, like many things, make a risk assessment and move forward. And if your assessment is that those other things are all more important, as much more important, and we're so resource constrained that even with those proposals, you don't feel like adding this to the pile, then we can make the decision today. And I can simply tell them that we're not going to be the fiscal manager and subrecipient. And that doesn't mean the project doesn't happen. It means it may not happen, but everybody else is going to have to make the decision if they want to play that role instead of us. And if you want to say that, my feelings aren't really hurt, because I see the same red flags along the way and have the same concerns. I'd like to know what Lisa thinks about that.
I share those concerns. I certainly don't have the resources available to spend much time on this in the next 3 years. I need to be honest, so.
If you're okay with the decision, I know what you said, Mitch. If you're okay with,
If you're willing to take that approach, I support it.
okay, I think it's time for me to just go back, and it doesn't mean the project's dead. The project was my idea to start with. CDOT, US Forest Service, Denver Mountain Parks, History Colorado, and the Indian tribes have all bought in, and they all want it to happen. I think I just need to tell them that we're the mouse in the room, and somebody else needs to pick up this thing and carry it. And thank you for liking the idea. I know somebody pitch in on that side and take the risk.
I mean, I part of your question is like, if this process is unfolding, should we participate? The answer is yes. Right? It's are we going to be the ones to pick the project manager, oversee it, all that stuff? And I don't see, I just, my opinion is that we should not make that commitment. I'm really, really interested in things like trying to save our transit program.
Mm-hmm.
And you know what I mean? Like the trade-offs are acute right now. They're extreme. And as important as this work is, I don't see how we can add it to the plate.
Well, I'm fine with that, and I'm fine with, I don't know if we need to take a vote or anything right now. Peter thinks we do. If we just want to give direction, and I'm kind of almost, Lisa and I are staff on this one. I do want to say this. This is one of my last, I have 55 days and 21.5 hours to go. And so I don't have that many opportunities to make clear what my feelings are about things. So with regard to this project, I just want you to know that the renaming of Mount Blue Sky was, I think, a great accomplishment and action that Clear Creek took to help lead and was kind of forced into taking the lead, but did a really good job of doing that. And it's a way, so I think that what this project is about, for me, is about a small county taking the lead and getting all these other organizations and people, again, one more time, to express what they think about, like humanity on earth and how we write history and how we tell the truth. And so to me, this is a really important project. I don't reluctantly take the message. I reluctantly agree with you that this isn't the right time to do that, for us to take that proposition. I really hope it goes forward and it doesn't die, because I think it's every bit as important as all the other things that we're doing in terms of how we how we decide who we are and how we tell the rest of the world who we are. And I know that on this subject matter, not everybody in the room even agrees with me on this stuff, you know, but somebody in here probably says woke. Look at that guy sitting up there saying this stuff, but you know, whatever it is, it is. That's what I am, and that's why I'm onto this project. And I'll go play poker with him and see if we can still make it happen.
Thank you. It is important work. It is. I don't want to invalidate that. I just, I've already said what I think about our ability to execute.
Yep. Okay.
And I do think, I mean, this gives any partner out there that might be thinking maybe they can do this, the best opportunity to pick up the bag.
Well,
They know
this,
right now.
yeah, it's actually gives me some relief. Now I know what I got to go do. That's good.
So we're agreed. We're not going to be the grant applicant.
Correct.
I think, let me just say this, we could only be the grant applicant if that does not include being subrecipient and fiscal manager. And it felt that way 2 years ago. I'm not sure if that's the case or not. Somebody's got to sign the paper and turn it in. We're not committing to be fiscal agent or anything like that. And I don't think you can be the grant applicant without being the fiscal agent and subrecipient. I don't know how you can do that.
I don't think so either. I don't think there's any realm in which we apply for money and get it and aren't ultimately holding the bag for the adequate use of that money.
Okay. Okay.
Hopefully, if Denver Mountain Parks, if you're listening, US Forest Service or anybody else eligible to apply, Idaho Springs. You value this work like we do and you have the capacity to actually do it. Anything else on this?
Nope.
Okay, thank you all. The next thing that we should do on our agenda is at least one of the executive sessions. Should we do both?
Randy, I think it was 2 p.m. unless you changed the time with.
We can't do both of the executive sessions right now on this short of notice. We can do one and then come back and do the other. Let's do the one.
Okay, well, we're just gonna do the one.
Yeah.
So I move the board into executive session for the following purposes.
So it's CRS 24640224B for the county attorney to meet with the Board of County Commissioners for the purpose of receiving legal advice on specific legal questions pertaining to participation in the Fire and Police Pension Association and other matters relating to the county budget.
Did you need to reference sub E as well?
No.
Okay.
Thank you.
I'll second that.
Okay. We have a motion and a second. All in favor?
Aye.
Aye.
All right.
The board will adjourn into executive session. Our minutes will be kept, no decisions will be made. We will return here. The next thing on the agenda when we do return is a work session to discuss building code and fee amendments. Thank you to staff for your patience as we work our way to that item on the agenda. The board has concluded its executive session. No written minutes were kept, no decisions were made. We have a second executive session that we are going to sequence now. But when we return from the executive session, we will have a work session to discuss building code and fee amendments and the rest of the agenda. Therefore, I move the board into executive session for the following purposes.
Pursuant to CRS 24 B and D for the county attorney to meet with the Board of County Commissioners for the purposes of receiving legal advice on specific legal questions pertaining to the county's 1041 regulatory authority over period children's within its jurisdiction and determining positions relative to matters that may be subject to negotiations, developing strategy for negotiations, and instructing negotiators with regard to proposed modifications concerning PPSL operations.
Second.
Motion is second. All in favor?
Aye.
Aye. Motion passes. The board will adjourn into executive session. No written minutes will be kept.
Right.
Come on down.
Okay. The board has concluded its executive session. No written minutes were kept, no decisions were made. Next on the agenda is a work session to discuss building code and fee amendments. Amy?
Yes, thank you. Okay, so this is a work session. We want to discuss a variety of changes to the building code. And just as Peter alluded to earlier, our still new Chief Building Official, David Danielson, came in and really hit the ground running, offering all sorts of structural changes and insights to ways we could be more efficient and effective as a building department. So today there are 5 basic things that we are here to talk about. One is that we are proposing the adoption of 2 new codes to adopt as whole codes. One is the swimming pool and spa code that will allow us to regulate hot tubs better. That is the existing building code, which is a section of code that we have not adopted. This will help us to better manage our older legacy buildings that are in the area, historic preservation, and to do better with that. So those are 2 codes that we are proposing adopting. Do you need some help? Okay. That we are adopting incomplete en masse, in whole, 2 codes. So that's one. Part 2 is that Dave came in and is recommending a whole series of building code amendments that we would like to add to improve some efficiency. He will talk a little bit more about that. So that's part 2. Part 3 is a series of amendments to our building fees. Heard about this a little bit as we've discussed the expansion of our building department to include service to Idaho Springs and Georgetown. This is a building fee permit, a building fee structure that is based on building valuation and the cost of the cost of delivering those permits. That allows us to make sure the fees that we collect cover the cost of our permit services for the building department. 1, 2, that's 3. Part 4 is that we are including a proposal and some information about our contractor licensing program in this package. And part 5 is some amendments to the building code that are related to the grading and excavation part of the building code, which is Appendix X. And that is related to that's why Stoy and Dustin are here, because the road and bridge manual, that full document has one part of it that is governed by the building code, specifically Appendix X. And so they have some amendments to that portion as well. So this is a little bit of a large set of stuff to review as a work session, but that is what we're here to do, is do large things. So that is what we're going to do. So Dave, I'm going to hand it to you to talk about the part 1 and part 2 to start, which is the codes that we are adopting and the amendments to the building code, to start there.
Okay, so to begin with, the new codes that we're suggesting to adopt is the International Existing Building Code. With the Unified Building Code approach coming up, it's going to be very important for us to have that existing building code to address those older existing buildings in Clear Creek County. We're going to adopt that largely unamended. There's going to be a couple minor amendments in the existing building code. The other code that we're recommending to adopt is the International Swimming Pool and Spa Code. So again, picking up Georgetown, Idaho Springs, there are a couple swimming pools and spas that are within those jurisdictions. And then that would also cover hot tub installations, which currently occur in Clear Creek County unincorporated. And that's where it'll be utilized for Clear Creek County unincorporated, largely unamended there. There's going to be a couple amendments to those codes, referencing them back to the IBC's administrative sections. So regarding the amendments to our building code, most of our changes are coming out of chapter 1, which are the administrative sections of the IRC and the IBC. For code enforcement practices, we're going to make some changes regarding when some of the permits expired, some of our reference standards. We're going to put a caveat in there if the Board of County Commissioners supports it for a licensure requirement for contractors in Clear Creek County.
There's a list in the packet.
There is a list in the packet of all the changes. Beyond that, is there any specific questions or concerns regarding the suggested amendments to the building code?
No. Can you talk to me a little bit more about, so like, as I understand it, existing buildings right now, when they go try to get a building permit, they have to comply with the building code that we have. If we adopt the existing building code, that would be the code that they would have to meet. Are the standards generally speaking looser, less loose? Is it an attempt to be more practical for you to remodel your home without having to redo your whole electrical system or something like this?
Right, so that existing building code is gonna mostly apply to commercial buildings and commercial occupancies. What it's gonna do is it's gonna make it more feasible for projects to take place in those existing buildings. There are certain limitations in the existing building code. When certain thresholds are met, more areas of the new building code need to be met. And so the existing building code really outlines and provides provisions for when and if scenarios of what levels of code compliance you need to bring your facility into.
So like, it is true that this is basically making it more practical for someone who has an older building to update their building.
Correct, yes.
Okay, thank you.
Dave, is there some part of this that is about being in alignment with the towns as well?
Yes, so there was an amendment to the existing building code. And that's down here at the bottom
In the red line, is this
in
where you're
the,
looking?
yes, in the red line version. Or the swimming pool and spa code. We're going to make an amendment to the existing building code to section 104.10 modifications. And in that specific section of the existing building code, we're addressing practical difficulties involved in carrying out the provisions of that code. We're going to allow the preservation committees of the local jurisdictions to have some authority over modifications to the existing building code when it might be practically infeasible to complete a project.
I have a question back on the portion George alluded to a little bit ago when he gave an example of the kinds of things that you have to do in existing buildings that this would maybe be more lenient on. And I don't know that the example he gave is one that would actually be affected, but I need you to confirm that. There's been typically in the past on remodel jobs, trying to remodel their house, once they go beyond a certain percentage of the system, for example, by the inspector's estimation or the plan's estimation, certain that if there's going to be an alteration or addition equal to a given percentage of the overall electrical system, then you're required to bring the entire house up to code once you exceed that threshold. Is there anything like that that's going to be affected by this existing building code because that's first of all, electrical's in the state's hands now, for one thing. And so it's not really a choice on our end. And secondly, so is there anything in that existing building code that actually impacts that particular idea? Because that's one of the biggest things that happens to people when they're remodeling is they find out they've got to bring their electrical system up to code throughout the house, even though they weren't planning to gut that other portion of the house, you know?
Right, yeah, so residentially, for single family residents, which is going to be most of the individuals in Clear Creek County, is only the areas that they are modifying are going to need to come up to current code regulations and current code standards. There's not going to be a threshold limit where you've remodeled 50% of your house. And we're going to require your entire structure to come up to new code requirements.
This was just on electrical they used to do.
Yeah, and we're only speaking to single family residential in that part. So.
Okay.
Any other questions on the two codes that we're adopting or on any of the amendments?
So the amendments to the
IRC and the IBC.
Yeah, okay, so the last one, the burial depth of gas line increased from 12 to 18. All the other jurisdictions are sitting at 18.
Yes,
We're currently sitting at some
12.
Is that what currently at, or is that just what the 21 code states?
We are currently at 12. That's what the 2021 code states. So Idaho Springs has chosen to increase their burial depth for gas line protection down to 18 inches.
Why was I under the impression that that was, oh, this is a broadband.
We were talking broadband, not gas.
Well, Excel talked to me about gas being out of line with.
We were at
with
5
IBC.
feet previously.
We were at something crazy like 5 feet, I thought. But we're not right now.
No, we're currently at 12 inches.
I think it was 5 feet in roadways. And that's what was driving people crazy was the, we were really getting hit on gas lines, gas line burial depth. And I think it might've been in road rights of way that it may have been a road and bridge regulation or something.
Yeah, that's a topic that's come up several times over the past several years, was burial depths in the right of way, which is not governed by the building code. And we have specific burial depths in the road rights of way that are outlined in our roadway design and construction manual. So it's a little bit separate from the building code
It's
here.
not covered by this, yeah.
No, so this is a separate that only applies on their private properties. And there's a different set of standards that apply in the roadway.
Thank you. More interested in the broadband conversation than the gas line conversation anyway. You know, we might as well just stop putting natural gas pipelines all over the place, whether they're 1 inch or otherwise. That's the only thing that came out to me as like, otherwise. No other questions. Any other questions?
No.
Okay.
Okay.
So I think next then I would ask you, Dave, to talk a little bit about the contractor licensing program specifically.
Yes. So starting from the building code, for the contractor licensing program, we would have to adopt a specific code section recognizing that contractor licensing is required for new construction, which we've done with the new code section. 1 second, let me get to it here. The new code section 105.1.3 permits license required. All persons undertaking work which requires a permit shall provided in 105 shall seek to obtain a permit from Clear Creek County, are required to have a current valid contractor's license in Clear Creek County. What we're trying to do there is ensure that all contractors and individuals performing work on the behalf of other individuals are adequately experienced, adequately knowledgeable, and have adequate insurance. So by providing this regulations, we're providing some consumer protections for everybody in Clear Creek County, the future homeowners, future building owners, everybody involved that would have work affected by any individual operating in Clear Creek County.
Megan has your document up.
Oh, she has my document up. Okay.
It's within the packet, so
Yes.
there's a specific thing. It might take me a while to find it.
Let me get my contractor licensing requirements up.
No worries.
So section 102 of the contractor licensing requirements specifically identifies the scope and purpose of the contractor licensing requirements. Generally to protect the public by ensure those undertaking construction, alterations, repairs, and demolitions of structures are qualified to perform such services. The rest of the regulation has been written to that end. I don't know what to touch on specifically here, which would be pertinent or important to the Board of County Commissioners to hear in considering this regulation.
You're talking about the licensing?
Yes, the contractor
licensing,
licensing
yeah.
requirements.
I think we're just a narrative of what you are requiring, what proof, what you're requiring in order to achieve that. What is your specific requirement in order to get that license?
Okay, so specific licensing requirements are identified in section 3.1. We are going to have at least 5 different types of licenses, class A, class B, C, D, and E licenses. Each one of those has a specific scope of which kind of work those individuals are allowed to undertake. Associated with each one of those contractor licensing requirements, we have the requirements of those licenses down in section 310, examinations of license approvals and issuances. In that section, we outline specifically what background information each
Mhm.
contractor will need to realize to obtain that specific license type. So a Class A license contractor has a little bit more stringent requirements to meet than a Class B or C license. Class D license is reserved for journeyman mechanical contractors, and then a Class E license is reserved for contractors performing a limited scope of work, roofing contractors, window contractors, siding, somebody doing a bathtub remodel or something like this. Electricians and plumbers will still be licensed with the state. So we won't be licensing those contractors. We will recognize those licenses though.
Talk a little bit about how this will affect the like a homeowner who's being their own contractor.
Yeah, so it is not the intent of the contractor licensing requirements to require homeowners performing work on their own property to obtain a contractor's license. So those individuals will still be able to work on their own homes.
And that's a matter of state law, right?
Yes, that is Colorado revised state statutes.
And then I think I've heard you describe a little bit about how this would get rolled out, like how would people who are currently providing contractor services in the county, how would we work with them? How would this transition in?
Yes, so that's somewhat addressed in section 312 probationary licenses. For individuals who have obtained permits in the county within the last calendar year up until December 31st, 2025, they will have a period of time which they can obtain a probationary contractor's license. At the expiration of that contractor license, they're going to have to meet some additional requirements to maintain and achieve a regular contractor's license in the county.
Questions?
How common is it do all of our municipalities require contractor licensing?
Idaho Springs currently has some contractor licensing requirements. Georgetown has some business license requirements, but it's very, very common for jurisdictions having authority, which have the building code in place to have contractor licensing requirements.
And my understanding is the towns have, at least on the contractor side, it's a little bit less robust than the program we're envisioning, closer to a contractor registration than any sort of evaluation of the credentials of the contractors. And when we've described these programs to towns, they've been very happy and receptive to seeing this sort of that we have the ability and willingness to offer this service and to help make sure that the people doing work in the county are qualified.
If the board chooses not to pass this, how does this impact our plans? Is this at all related to the Unified Building Department?
Not directly. We have put some projected revenue in the budget for this program.
And probably if we projected some expense.
You're talking about,
Not directly. I don't believe there's any projected expense for this.
No, this is a cost recovery program. So any expenses it takes to administer this program, we will recoup through contractor licensing fees.
That's what I mean. Basically, if the program doesn't exist, you could find something else to do with your time.
Yes, we could.
there's that too. Yeah.
And I don't, I mean, with your job while you're at work, just to be very clear, like.
It's providing a benefit to our community also, right? To know that someone's licensed in terms of doing their work. I was a little shocked that we don't have this at the state level, having that, seeing that in multiple states I've worked in, so.
It's gone up and down. It's gone back and forth here, but there's never been a state. I know there was virtually never a state a general contractor's license requirement. There's never been one here that I knew of.
So we just went through the ISO certification. And part of that ISO certification, there's a rating system that's scaled 1 through 10, and depending on the structure of your building department and some of the background requirements that you have, one of which being contractor licensing, you obtain a higher score. And as you obtain a higher score, it benefits the residents of the county because they end up getting a lower insurance premium for their house. So this would be beneficial as a whole to all homeowners, besides just ensuring that they're going to have a licensed contractor performing the work, they're going to be knowledgeable, but they could potentially see a reduction in their insurance costs on their home.
Yeah, it feels like a little bit of a stretch that we can get our ISO scores much better without like a dramatic change to firefighting infrastructure around the county.
Yeah. Well,
I don't like, that's my initial reaction because we've spent a lot of time on the fire department board looking at ISO scores and what we can do to improve them. And basically, if you're not within like 500 yards of a fire hydrant, you're not going to have a very good ISO score, and there's nothing you can do about it.
Perhaps that's the case. So that may not be an argument for the contractor licensing program, but it certainly can't hurt our scores. And
Yeah.
It is an enhancement to consumer protection and to the quality of work that's taking place. I mean, there are cases where having a contractor conduct work on a project is eyebrow raising. And it's because their qualifications are questionable. And it does limit our ability to use the code in the way the code is designed to be used.
I'm not looking for a license, but I'm asking this question for a friend. But I'm seriously not looking for one because I know I could end up getting a license. But there are unique, what I'm looking at is the under in the section directly under 3.1 before you get into 1, 2, 3, and 4. The sentence, it just says you can get a license by satisfying one of the following provisions, and there are 3 basic provisions: an item from 1 and an item from 2, which means that you have to have passed the requisite exam for that license, as well as, depending on the type of license, X number of years of experience, and then satisfy 3 and 1 item from 1, 3 being hold a bachelor's degree, and also take one of the tests. And you can argue which of those is more or less onerous. Granted, you got to go to school for 4-ish years to get the degree. Most people learn a portion of what they're going to need to know to do those things when they go through a 4-year college program. And then the third one is satisfying 4 or 5, and either 4 or 5. And that's, you've had a probationary license. If you have a probationary license, you can get a regular license upon completion of not less than 32 hours of code-related education, et cetera, or holders of equivalent licenses. And is that current holders of equivalent licenses or history of licensure? And I'm going to offer myself up. I'm a person with 40 years of experience that I can mostly demonstrate and document. And I've held a Class A license in Jeffco, which means I can build anything. But that's long expired because I've been a county commissioner for 8 years. So is that start over from scratch and go back to college, or what is it?
No, at that point, the section 5 here is specifically addressing reciprocity. So individuals who are holding active license in other jurisdictions will be able to come to our county and obtain their contractor's license without jumping through all these same hoops. Individuals who have had licenses that have been expired more than a year will have to go through and meet these requirements again. So since you have the experience, you would satisfy that requirement already. You would just have to demonstrate the testing again.
Take a test again.
Yeah.
I've been tested a couple times for licenses, but okay.
Yep.
That's what I want to know, is if you're required to do that again. So,
Do those tests cost a fair amount of money? Are they readily available?
They're readily available through the ICC and they do cost a few $100s, yes.
And I'm not looking for that work, just so you know. I figured you only live once. And so if you do something for 40 years, why would you go back and do it again, even if you do something different? You know,
Sorry, Mitch.
Yeah, I drifted away, so you get to go.
The question that's in my head. What is the bigger problem in the contractor, in the supply of contract services in Clear Creek County? Is it the quality of services or is it the availability of services? Might be both, right? Those are not mutually exclusive, right? You can struggle to find poor quality services, which is probably where we're at. Generally speaking, I don't mean to cast aspersions on every contractor in Clear Creek County. There's a bunch of good ones that are really busy. Really, really hard to find contractors in this county. Kind of concerned about what this policy might do to make that situation go from bad to worse.
Well, I think it's positive moving the due diligence from the property owner or the person who's hiring them. And it doesn't totally remove it, but it does change the due diligence process that a homeowner would have to go through.
Yeah.
Now, I look at everything that's in this document and makes me think I wouldn't have to work as hard if I wanted to renovate a kitchen.
You just have to work well, you may have to work harder to find somebody and you may have to work harder to afford their.
you might have to work harder because you have to renovate the kitchen instead of hiring someone.
Yeah. And I'm not expressing a strong opinion. This is the board's first stab at this. I almost kind of want to ask for a little bit of public process around this. Right? Like maybe we can ask the public some questions about what kind of challenges they're facing. You gotta work on your poker face.
I mean, I think getting some more data, I think could be helpful. Some of the things that was before you mentioned that, what I was thinking was providing you some data on whether introducing contractor licensing programs expands the available contractors in a community or reduces it. Because it may be that when you expand this, that especially with a reciprocal program, that this incentivizes contractors who are working in neighboring communities who are licensed to add their names to our list of licensed contractors and join our program so that they are, available to our community as well. It may enhance that availability, but I don't know if that's true or not. I'm not 100% sure that a public process is exactly the way to get at whatever your questions are, because I think there are questions that might not be the best way to get at what you're looking for. It may be a cumbersome and challenging process to ask this question, and it may get answers that are not fully informed or fully shed light on what we're really trying to get at.
It's kind of like asking people whether they want to pay more or less or make it more. I think it's, having regulations does two things. Number one, it induces, it actually levels the playing field a little bit, having licensure. Because you'll say it doesn't because certain people are eliminated, but what it does is if our object is to create quality work, what happens when you don't have, for example, I'll give a similar example over in Delta County and other counties in the state. There is not only not a contractor licensing, there's not even a building department and a building code other than state requirements, and environmental health, stuff like that. And so your state licensed people still have to get inspected and pull permits at the state level. And otherwise, it's a free for all. And what that means is that competent licensed contractors who do have all their insurance and have all the stuff they're supposed to have and have gotten licensed or educated, or at least are having to pass inspections, people that do competent work stop coming around because they're competing with anybody with a hammer. And they with, or just a cell phone and a checking account, you know? Anybody can be a contractor in that environment. And what that means is that it generally drives down quality and it drives down price.
Right.
And what happens is the people that know how to spell business overhead and stuff like that just withdraw because they can't compete and deliver what they're used to delivering, you know, whether for whatever reason, that's their business model. And so what you're left is those who are less qualified doing the work.
Yeah.
And it's hard, and it becomes even harder to find. Now, we do have a building department, we do have building codes, and people do have to meet those regulations here at least, and they have to get inspected. And so that weeds out a lot right there. Then the question is whether licensure, you know, provides that same dynamic to the industry. And you could argue that at least, you could say that there's people that maybe don't, it's possible maybe that there's people that don't compete here because they're fully licensed, accredited, educated contractors somewhere else, and they don't have to compete with that here, like they do in Jeffco or somewhere else. The Jeffco contractors don't want to come up and compete. But I don't know if that's true or not, because we can't find contractors at all here right now. It seems like it's wide open for,
Right.
for somebody to come in and the price, and unlike in some of these other places, the prices aren't down here to hire a contractor right now because of the availability of them at all, because we're so close to the Denver metro area.
Right.
So I know I'm not getting us anywhere on this. I have some mixed feelings about it. I like having contract licensure on top of having building codes and stuff like that. I also recognize we are where we live, and I hear George's comments. And so making it too onerous to get in and get in on the ground floor. The reason I bring up experience, it's easy for me to say, oh, I got that one down. Well, yeah, I should by now. And, but how do you know, it's a kind of a cart and a horse problem. If you need to have, if it depends on what you need, 5 years of experience or 10 years or 15 years of experience doing what? It says related to the license that you hold. And so how do you get 5 years of experience as a general contractor if you can't get a general contractor's license? Because you don't have 5 years of experience, you know, you just around in that loop, around in a circle. How do you get in to begin with? So what kind of experience do you consider in as aggregating towards that 5, 10, and 15 years of experience? That's the question I would have, because I don't see it spelled out here really clearly.
Yeah. Generally, that experience that we'd be looking for would be working under somebody that has that contractor license that you're applying for. So for instance, if you're going to get your first Class C license and you have your 5 years minimum experience, you would have had 5 years working for a Class C contractor, Class B contractor, somebody of that sort, and that would be demonstrating your work experience. And it would just be a short resume submitted via an affidavit.
So you're a framer for a contract for a Class A licensed person, and 5 years later, or whatever the number of years is, you meet that requirement.
Well, if you're, yeah, it depends on whether you're an employee of theirs or you're a subcontractor to them. When you start, you say framing as an example, that's normally a subcontract, a general contractor.
Okay. Thank you for indulging this rabbit hole. I have some, I need to express those concerns. Randy, what you're saying is pretty darn persuasive. I could be talked into implementing a registration program to build some data, build an audience, to start asking some questions of, hey, would you meet these requirements? You know, like I have some the questions I have out there is like, who's currently in business right now that we're putting out of business, right? Who's like, those are some of the questions in my mind, and I don't know how to answer them.
So these are drafted and written in such a way that ideally we wouldn't be putting anybody out of business. That individuals who are already working in those trades and in those fields through our probationary licensure will be able to get a license next year immediately. Our goal here isn't to put anybody out of business. It's just to maintain that minimum level of education and demonstration of experience.
Yeah, I mean, I would say there's a good deal of entrepreneurship in a small environment like we're in, population and business environment like we're in. There's a good deal of entrepreneurship that happens for people to even get by and find and become contractors. And so I support the idea of the system right now. I look at those requirements to get each one of those types of licenses and say they may need to be relaxed a little bit in order to give people even the opportunity to not dissuade people from trying to do it to begin with, because, you know, you can go to school for 4 years without working in the field and come out, or you can go to work for somebody for 5 years and actually do the work and in order to get there and test out. Those are kind of equivalents to each other, and I kind of get it. But there are people that come out and start working in that field that are given opportunities. People want them because they're demonstrating quality work and they want to start that business, but they got another 3 years. They got to work as, you know, it's kind of like indentured servitude or something after a while. I had an experience like that in school where I was already operating as a licensed contractor, doing the kind of work that I was studying and learning to expand. And I was told that to get this last class and the hours in that class and graduate from school, I had to go intern on a job working for one of my competitors in order to get my degree. And I said, you know, I got all the rest of knowledge. I'm not going to be slave labor for one of my competitors in order to have you give me something that I already know how to do and I'm doing at this time. So it's just that kind of thing that you're dissuaded from doing it because you're trapped by the system and remaining at a certain level for too long a period of time, I think. So that it's that 5, 10, and 15 years of experience, and what particularly counts towards that experience that I think needs to be, you know, 5, 10, and 15 might need to be relaxed in some manner. And in my opinion, since it's not an apprenticeship program, and then to be more clear about what those experiences would be that would qualify you to move up into that level.
Right.
Okay, that's good direction. I think we can, when we bring this back, we will add some more, maybe some softening a little bit of the probationary opportunities make sure that we are doing our best to include our existing contractor pool, that this doesn't exclude anybody unless they are unqualified and being, you know, causing harm, you know, being harmful, which is what the goal of this program is intended. And maybe we can also bring you back a little bit more data on our current contractor pool to just help shore this up just a little bit more.
I do want to point out that the grand majority of the work that happens in Clear Creek County would be finished and completed by individuals holding Class C, D, and E licenses, which are the most easy to get. The Class B and A licenses are really projects that an outside contractor from outside the county most likely would come in and do. These are new home builds, major demolitions of structures. Class A license allows you to build any structure. So that would be a 1 million square foot warehouse, which an individual probably wouldn't need.
Office building.
Yeah, an office building, whatever. Most individuals taking on that work would already be licensed because it would be a requirement and a condition of the loan.
Right.
So I don't think that the A and B really need addressed,
Yeah.
but we could definitely take a look at C, D, and E.
C's entry level, I think that's where you can build a single family, or you can build, you know, the typical 2-story type thing or something. And it's C and B, there's some kind of overlap in there, but the B, I agree. If you're getting into multifamily work and you're getting, you know, commercial and multifamily, and especially an A license, you know, require whatever you want to. You shouldn't be able to build this. I held an A license in Jeffco, so I could have built anything in Jeffco. And there is 90% of that stuff I would have never taken on because I wasn't qualified to begin with, if you want to know the truth. So even there, so I get it.
So we have 2 more topics to cover in this work session. And I want to acknowledge Troy and Dustin, who have been sitting here waiting patiently. And so I will,
Sorry, quickly before we move on. In answer to the question about how this compares to our neighbors and their contractor
okay,
requirements would be helpful.
great.
Yeah.
What I thought we would do is move on and go to amendment, Appendix X, and just let Dustin and Troy talk a little bit about what is included in their portion of the building, and then we will wrap up with fees as our final topic.
Yeah, I'm piggybacking on Amy and David's presentation here for this work session, just because I have asked them to include some fairly minor amendments to our grading and excavation regulations, which are housed in our building code and have been. And so they're titled as Appendix Chapter X. I think they start around page 20 of the document that David and Amy had provided to you. And they're largely intact from what they have been adopted historically. But I am proposing a few minor revisions in there that I just wanted to run by the board with this opportunity of the work session. And the subsequent building code adoption. Are there any questions to begin with? As far as the list of changes there, or would you like me to kind of go through? There's it looks like, I've outlined kind of 6 areas that I've updated in that. I can just run through the list if you like, or if there's anything standing out that you'd like me to address or have any questions about.
Yeah, what are the changes to the deviation criteria?
So the deviation criteria before was intended really to provide a deviation process solely for the grading and excavation regulations. And the grading and excavation regulations are meant to govern site work on development projects outside of the public road right of way. And so this is, primarily single family residential development and other developments here in Clear Creek County, unincorporated Clear Creek County. And, the existing regulations have a deviation process that was really straightforward, that allowed the county engineer to provide for deviations within the grading and excavation regulations. And then just had some simple language to provide an appeal to the Board of County Commissioners if that decision was challenged. What we've done in regard to the deviation process is add some very simple language in there to also include the reference documents that are governed by the grading and excavation regulations. And the intention of that is to reference our roadway design and construction manual, or at least sections of that govern driveways and parking areas. And so that's really just bringing that deviation process to not only apply to the grading and excavation regulations, but also the driveway standards and kind of those road standards as they would apply to development projects. And so that was one minor change that we included in there, just to kind of bring that process together. And then in addition to that, we just added some criteria in there rather than just broadly, we had some broad language in there that the county engineer can provide for deviations to the grading and excavation regulations. We wanted to list some criteria in there to be like, hey, here are the considerations that would be considered when making that determination, as well as some specific criteria that's to be evaluated when going through a deviation request. And so we've added that criteria in there. Happy to kind of go through that and the different considerations that are included in there, as well as the criteria. And then just some submittal requirements, some simple submittal requirements that are expected along with the deviation request, so that we don't get just a really broad deviation request. Just like, hey, I want to build a 20% driveway. We would also like some review of alternative designs in that and some narrative to justify, how that they're kind of meeting the considerations and criteria for this deviation process. And so some just simple submittal requirements in there to help provide some guidance for that deviation request process when that comes in. And so that's really the majority of the revisions that we're asking you to consider and in this manual. And again, it's kind of this odd area where, it's these kind of these separate regulations in the roadway design construction manual that primarily addresses work in the road right of way, but also contains the driveway standards in there. And so that the driveway standards, the chapter from our roadway manual, has historically been adopted as an exhibit to the building code. And then this appendix chapter X is embedded into our building code as a building code amendment, which just provides for some additional grading excavation regulations. And so it's trying to bring all that together and kind of provide one kind of consistent permitting guidance and process for both driveways and other grading permits.
Okay, thank you.
Good.
Okay, I think we're done with that part.
I think this will come forward, the specifics with this will come forward with the process that Stoy will manage to adopt the roadway manual.
Thank you for that, Amy. And yeah, I think it's worth noting that, that my goal is to present this board with revisions to the entire roadway manual on December 10th, for your consideration. There's just some minor revisions throughout that document, some revisions to the driveway and parking area standards that we've discussed with the board here through a couple of different work sessions over the course of the past couple of years. We think that we've kind of taken that direction from the board from those work sessions and incorporated into the proposed revisions that we'd like to present to you on December 10th. That cover the driveway and parking area standards, and then some other just kind of routine corrections in there. I have heard you about burial depths for utilities in the road right of way. We're going to be taking a look at that and take a stab at that. We're talking to Beth, who's kind of one of our leaders in this broadband initiative, and some of the challenges that and feedback that she's received. And along with our public works director, Carl, to kind of discuss, some revisions. Just to clarify, on that point, there's fiber is not mentioned in our roadway manual, so there is not a set standard that addresses fiber, specifically. So I think there's been some words kind of put in our mouths in some cases, in some of these proposals. But that being said, I think there's some room to maybe clarify some stuff and maybe include fiber in there and maybe, provide some direction in that. But in the case of other communication conduit lines, whether it is a cable line or a telephone line, we do have a table that covers those specifically, and we have them separated. We have a burial depth assigned for a service or distribution line, different burial depth for a main or a trunk type line. And so there is some two different areas there. They're not very well defined. What is a service line versus a main line? Is it?
Are you talking gas now or back to?
Both, it's listed for gas, for water, for, I'm not sure if electric, has two separate, categories there, but definitely in communication lines, cable, communication lines are called out separately, and telephone lines, are called out separately, but we don't have a category for fiber type of communication lines. They've been kind of administered similar to the cable and telephone lines, which do for the distribution lines, for that category, has I believe it's a 2-foot burial depth. And then when you get to that trunk line, then it does jump to that 4-foot burial depth, which I think people have seen and has really caused some concern. That's like, hey, this whole thing has to be built at a 4-foot depth. We do want to take a look at that. I don't know that we're ready to propose something to you that would be, hey, let's do everything at 18 inches or even 24 inches. I don't know that our road and bridge department is really comfortable with that because we're seeing a lot of damages to the existing infrastructure that's in there. And, our contractors hit these existing communication lines. We do when we're doing ditch maintenance and replacing culverts and other areas. And so there's real concerns about, this burial depth, and it does come at a cost when we damage these. We just damaged one last week that feeds the transfer station and killed the communication line, such as it is to the transfer station for a couple of days. And that's the third time in the past couple of years that's happened to that particular line. And so there is, we do have justified reasoning for, requiring a certain depth on that. But I just want to acknowledge that we do hear you. We want to take a closer look at that, make sure we're kind of in line with our adjacent communities and.
Well, I remember from this being one of the first things I addressed when I came in 8 years ago with Sean was gas line depth. It was the first thing that popped up on my radar when I got here. And I know we went through all the due diligence at that time, and I requested it to examine all the counties around us. I called around to a bunch myself. We determined that we had a 5-foot gas line depth. And I think the question was, they were trying to achieve adequate depth beneath culverts and ditches in the road right of way so that they were protected. Plus, there was this very onerous 5-foot depth. And I can't remember if the issue was that we had to get 5 feet beneath the lowest point or the point where it was running. So they had to be 5 feet below those access points, culverts and so forth under driveways, which puts them down to, they're trying to dig into granite. You got to go 7 feet down. It made for extraordinarily expensive lines. And so it ends up being ultimately borne by the consumer at the end of the day, because one way or another, the overhead filters down into your cost. And And when we looked at all of the counties around us, we determined at that time that we were way more than everybody. And we got the answer back that, well, that's what we feel like we need to do here. And there was no give on the other end. And it was from Road and Bridge. I'll state that at this time. So that's been one bone of contention that's lasted the last 8 years. And if we hadn't, I wouldn't feel as strongly the need that George, same as George that he brought up, had we not demonstrated already once and gone through the whole thing to see what everybody around us was doing. And we looked at places all around the state, trying to see like, where is there anybody like us in the mountains or anywhere else that's doing this? And there were only a couple of 3 places that were running this, the kinds of depths we were requiring, and it was specific to gas lines. The gas lines were seen as especially dangerous, and so we were forcing them way down into the ground in a place that it's really hard to get into the. So.
Understood. And I don't want to derail Amy and David's presentation too much, but we will take a look at that along with other direction that we received from the board, and we look forward to presenting that to you on December 10th. That will include those driveway and parking area standards as well for your consideration at that time. If the board chooses to adopt that, then it gives us a really good opportunity to then re-adopt them as part of the building code, the new standards, so that we have consistency in both the roadway manual and the building code, especially in regard to that specific chapter on driveway and parking area standards.
Thank you. A question I'm likely to ask is when you hit something at the current depths, is that evidence that it needs to be deeper, or you need to do something differently when you're digging?
It could be both. I think both scenarios exist there. But just again, I think most of us are familiar with this problem we've been having with Soda Creek Road with the water, coming up to the surface there in the middle of the road. We've been working on that. We've had a contractor in there to kind of place the fix for that, this manhole and drainage system under the road there. As they were doing that, they went through the typical processes of calling in locates and locating the utilities there, and still managed to get this communication line. When we did the paving project, we also replaced the culvert just a few hundred feet downstream of this area. When we replaced that culvert, or when our contractor replaced that culvert, they also hit this same line, because this one line is not very, very deep. And as Randy was noting, a lot of times we get into bedrock in these situations, and it's very difficult and very expensive to bury those deeper. But we have the same conditions that we need to kind of get down deep to place our culverts, or oftentimes replace our culverts. And if that utility line is over the top of the culvert, or in between culverts, or directly underneath that culvert, and really a bedrock, a communication line, and then a culvert sandwiched right on top of each other, then oftentimes when we pull that culvert, it gets damaged just because they're in conflict with each other. And I don't know, you don't really need to point fingers, and it's like, oh, it's the contractor who's replacing the culvert, or it's the communication person that installed that. There's real challenges in that, and real expenses in that, and burying those deeper. But that is part of it. And oftentimes when we go through and replace culverts, we're upsizing those culverts as well, because they don't meet our criteria for accommodating a 25-year storm event, or if we're able to to even accommodate a larger storm event. So if we have an undersized culvert, and we have oftentimes, gas lines that are under and over it, along with communication lines that are all kind of interacting together in this small soil envelope sitting on top of bedrock, and they're all sandwiched together. So it's not an easy problem to really solve for any of us. But I just want to note that there is expense on either side in the installation of trenching this stuff in, but also when we damage this stuff, it comes at an expense too. Either we deal with the outages and all the expenses that come with that, losing your service for a certain amount of time, and then the cost of the repair. And my understanding is that fiber, especially when you get into larger fiber lines, that becomes even more expensive. Those repairs on those lines, and oftentimes they're serving larger service areas, and so again, we just want to think about that and make sure that we're not setting ourselves up to install a bunch of fiber lines that are going to get repeatedly damaged and cause a lot of outages and expenses in the long term.
I understand that you want it deep enough. I just say that 5 feet beneath the culvert is a lot. That's all I'm saying.
No, I understand that.
5 feet to make sure you're below the culvert's one thing. 5 feet below the culvert is like, you're kind of breaking out on the other side of the planet pretty soon. So
Yeah, and I think that there is room to reevaluate that and make sure that we're, kind of in line with others, and providing, appropriate protection for these utilities when they're installed. And apologies that this has not been addressed before now. I have heard it before and I have not yet addressed it. There's that along with several other things in this roadway manual that we really wanted to get in front of you for your consideration and show that we've, heard your direction and want to present you with that. And this is one of those items. I don't have a preview for you on this particular thing, but we're meeting with Beth and Carl currently and we'll talk about what those depth requirements are and see if we can provide some clarity in that and see if we can relax those in some cases.
okay, thanks.
Board too, I just wanted to better late than never introduce Dustin Bertelson. I don't know if you've had a chance to meet him yet, but Dustin works with Stroy in site development and he also works in the annex. And I get up the pleasure of working with Dustin quite a bit. He's new and really competent. Well, new might not be a great adjective. He's been with us for quite a while now, but he's really competent and a great addition to our team.
Thank you for that, Amy. And I'm
Yeah.
sorry if I was negligent in introducing Dustin here, but he's been with us over a year now. And he is here because he is the one, I'm helping, kind of, provide for some recommended revisions to some of these standards. But Dustin is the one that is tasked with administering these grading and excavation standards and driveway standards as people come in for their permits. And he's doing great at it.
Yes.
Thanks for choosing us, Dustin.
He's also doing some code enforcement work. Indirectly, one way or another, he is involved in many code enforcement cases.
Yes.
Okay, fees?
Yes, this is our last topic of the 5 for this massive work session item. Everybody. So for fees, there is a draft fee schedule included in your packet. And as I mentioned in the intro, and you have heard about this topic as we've discussed in a couple times with the discussion on the expansion of the building department. The main newsflash, I think, of this item is that we are proposing a change to the way we calculate our fees. That's based on a formula that basically ensures that the fees we collect cover the costs of the building department. And so that's the headline. And I'm going to hand it to Dave to see if you have anything to add to that.
Yeah, so that's a very good start for what we have here for our building permit fee schedule. It's a cost recovery method that utilizes the building department's previous year's annual budget adjusted for inflation, which we're going to eliminate anomalies out of that because we are a small community. We have some projects that come through that could cause a major fluctuation in our cost of construction. We'll divide that by the total annual cost of construction for the year prior to come up with a permit fee multiplier, which will be applied to a permit fee. So once we have a permit fee multiplier, we have our estimation or guesstimation of what that cost of construction is, or we will use the building value database from the ICC, which is a multiplier based on square footage of construction and construction type to come up with our permit fee on an individual basis. So for work other than new construction, the permit fee shall be calculated utilizing the cost of construction, materials and labor, or as determined by the building official, whichever is greater. So that just allows us to address when people have egregiously undervalued their project and have provided us with maybe only materials or something like that. We have a fee schedule down below with other fees as applicable for additional costs to those permittees. Some examples are temporary certificates of occupancy, residential temporary certificate of occupancy, wildfire hazard mitigation, development and inspection, deferred addendums when they don't have all their submittal documents up front and ready for us when we have to go through and do additional plan reviews. We have a fee associated with that as well. Any questions regarding the permit fee schedule?
I feel like we've had this conversation recently. And I think I asked a bunch of questions.
There were some of this came up when we discussed the expanded building department. We did dig into the fees with some bit of a shovel.
You got anything about archaeology tools?
I don't know. I don't know what's going on.
Anyway,
It's late.
I don't think I have any, I don't think I have any questions. I don't know about my colleagues here.
No, I'm looking at the permit fee thing still right now. I just don't, yeah, it all makes sense to me. How much you spend divided by how much value of how much you're working on. And then when you do the permit, you take the value of that project and multiply it times that multiplier. It's pretty simple.
This formula did come from the ICC.
Yeah,
We
it's
did not
pretty,
invent this.
pretty basic. And construction cost is, of course, is cost per square foot based on what you're most recently seeing. And do you adjust that according to the type of construction or do you not?
Yes, it is adjusted. If you go to the ICC and you look up the construction valuation database, it is divided into the types of construction and the square footage and then the occupancy group too. So depending on the type of occupancy, which it is, and the type of construction, it might have a higher valuation. So for instance, like you had an ambulatory care facility, if we were putting in a hospital and it was 2B construction, it would have a higher valuation than a 2B building that was utilized for simply storage. So the ICC does a phenomenal job of breaking down cost of construction based on occupancy group. So it's very specific to what you're building.
Well, I think the place where you get the widest deviations that cause the most heartache or give some people the greatest deals are when you take for example, a single family residence. That's where it gets really dicey because there's a really wide range of construction costs there. So if you settle on one for single family residences, someone with fairly small projects can get dinged pretty hard based on that cost. Whereas although there's an economics of scale on larger projects, but larger projects are also where you see a huge amount of valuation and a huge increase, exponential increase in the amount of materials required and stuff like that. So using that one flat rate in single family residential can produce some really weird results sometimes. And if somebody's building a nice, got one thing you're using that strikes a median, somebody can be building a nice huge place and be thrilled with the price of their building permit and someone else might not be.
Yeah.
They're on the low end, so. Just a comment. I'm not saying you should change anything, other than if somebody might be able to make that case to you that they think they're grossly overvalued at some point. And I've worked in places where they actually asked us they wanted to see some evidence or understand what the construction value of what is our budget for this project? They'd come at it, like there should be a process of appeal where somebody can present their actual budget for the process. Of course, you got to be able to weed out the BS so that doesn't become a loophole if people are gaming. But,
I can speak to that a little bit. If you're using the ICC information, that is pretty low. That's basically the bottom floor, lowest amount of cost per construction you're going to get. Currently, like a single family residence is valued at $165 per square foot.
That's not going to happen.
Nobody's building for $165 per square foot anywhere. I mean, around here, it's $250 to $300 on the very low end materials and labor.
Right.
So it's fairly favorable using the ICC information.
This is a work session, so I would just encourage you to think about whether you need to put a modifier on that in light of that fact that you just elevated.
Yeah. So I've thought about the modifier and I know you're not looking for an answer right now and we can think about it a little bit more. But if everybody's appropriately lower than what the actual cost is and everybody's on the same playing field and we're using that permit fee multiplier, it's not really going to make much sense to have a regional modifier.
It's like right off.
Yeah.
Yeah, the only thing I would state is it sounds like where I'm concerned that here's your model and there's some people that are getting hurt that are down here. It sounds like the floor is down beneath everybody. So nobody's getting a raw deal. There's just some people that are going to be getting really, really great deals in terms of the actual amount that it costs them once they get up to, that 8,000 to 10,000 square foot place, because it's kind of like boats, it expands, take the length of the boat, it's exponentially. Once you run to 3 dimensions, it gets a lot bigger in materials. You got to cube it.
Refresh my memory, what is going to trigger the annual evaluation of the fees?
Do you want to speak to that or do you want me to?
I want you to.
Okay. So what's going to trigger the annual evaluation of the fees is our annual budget and our last year's previous project. So this is going to be something that happens every year regardless as we approach the end of our calendar year. We're going to use the trailing 12 months of construction data information, and we will use our projected budget for the next fiscal year, the next calendar year. The building valuation data that we're using is going to be the most recent building valuation data table that's been released. They released two of them a year, one in February and one in August. So we'll be using the most recent one.
Thank you.
Mr. Chair, I want to add to that. So we're going to modify our budget process also to ensure that all of our fees are reviewed on an annual basis as part of our budget process in terms of what we bring to you for proposed budget in the end.
Thank you. Would welcome that. Anything else?
No, that covers it. Well, what I can tell you is we will be bringing this back to, for a resolution, for your consideration on
Right
on the
now.
17th. Yes, on the 17th. And so that's when we will consider